In a city that never sleeps, a lone guitarist makes his leaps. Fingers dance, strings sing a tale of a dream that feels so frail. Echoes fill the silent night. A lost love, a heart so tight. But in this cold, hard world, hope's just a fleeting word. Oh, dreams whisper, oh, dreams sigh. In the darkness they take flight. Heartbreak echoes, lonely cry. In the cold, hard light, guitar soars through the stormy skies. A melody that pierces the eyes. Love's a memory, a distant dream. In this world it seems. Fingers glide in the fading light. A final note, a last good night. Lost in the shadows, lost in time. Dreams are all we find. Oh, dreams whisper, oh, dreams sigh. In the darkness they take flight. Heartbreak echoes, a lonely cry. In the cold, hard light.
In the shadows where whispers dwell,
1.3.
slight guitar sings of love's farewell.
10-4, I just wanted to know if
Echoes of the heart once bold, now lost in the night's cold fold.
Yeah, I'll be 23 back on
Secrets
the property
hidden
case. I'll be
deep
76
within,
of those Williams Road address.
tales of love that couldn't win. Promises made in moonlight's glow, now broken like a shattered show. Sorrow in the guitar's cry, resilience in the sky. Through the night we'll find our way, carrying secrets, holding on today. Memories of laughter and tears. In the silence they appear, whispers of a time so true, when love was all we knew. Lost in the echoes of the past, wishing for what we had. In the dark we search for light, holding on to what we fight. Through the pain, through the night, we find strength in the fight. Sorrow in the guitar's cry, resilience in the sky. Through the night we'll find our way, carrying secrets,
21.
Start me a card for a parking problem.
Foreigner 23.
We're on the 28 on truck when you're ready.
This investigation was bullshit. Those are reportedly the words of current U.S. Attorney Leah Foley, current Boston U.S. Attorney. This investigation was bullshit. As you know, I'm talking to sources daily now, and that is reportedly what she said. I don't know exactly at what point. She may not have been in on what it sounds like possibly she was. I'm just guessing as to when she said it. It might have been February. So as we know, the representatives of the U.S. attorneys. So Josh Levy, the U.S. attorney at the time, who spearheaded the investigation through some connection to Karen and her team, left office, I think January 20th, somewhere around there, with the change of administration. But even after that, so is the end of January. I believe it was January 31st. We learned from Hank Brennan during one of the hearings that the U.S. Attorney's Office told them that the investigation was ongoing. Now, some communication went on, it seems, between Brennan's office and the U.S. Attorney, the new U.S. Attorney coming in, Leah Foley. And so this may have been the point when Leah Foley looked into things and said, "What is this here?" This seems to have been an investigation without predication. So where this leads, we don't know. You know, at the end of the day, it requires people of courage, people of integrity. Integrity without courage is nothing. Integrity would not. That's a college professor in their perched in their ivory tower, pretending to have courage when they're not risking anything. You don't risk anything. You don't really test your integrity, so you don't really know if you have it. So whoever's in that office now they're guided by a myriad of influences. All the good people that work in the office with them, whose names they don't want to besmirch, people that are doing and have been doing good work to protect the public, people that help lead to the indictments in the Birchmore case. And then there are also rules and precedent as to how to deal with these situations that come from Washington. They're not laws, they're rules, they're policies, so they can be changed. But sometimes someone has to be a maverick and push this when there's wrongdoing, especially in the federal government, because there's so little oversight. It generally requires, we'll use the word loosely here, whistleblower. Whistleblower is a more legal term, so it's not always the right term, but requires someone to take a chance to do the right thing, someone to risk something. That's what integrity requires. This investigation, this federal investigation, is what she was talking about. The U.S. Attorney's investigation into the Karen Reed, into the murder of John O'Death, into the investigation into the murder of John O'Keefe, was bullshit. That's what the current U.S. Attorney is said to have said. And this needs to come out. All the truth needs to come out. And most importantly, the feds would have done initially a sweep of just basic stuff, as we know they did as they started the federal grand jury subpoena process. And these don't require warrants. They don't require probable cause. There's no affidavits. It's just a subpoena from the grand jury. And that would have included, we know, in November or December of 2022, so pretty early on, they subpoenaed the phone records. So this would not give you content. It would just tell you who called, when, and where, that kind of thing. One of the other things that's typical, and we don't know if it was done here, but one of the other things that's just done as a matter of recourse here, because you only need a subpoena, is to get geofence. Now, geofence is, let's say there's a murder across the street of your house last night, and the police want to know which devices were active within that area within a time frame. And so they reach out to all the various big communications companies, Verizon, Google, AT&T, whatever, and they find out, they give them a geographic location, so a perimeter and a time period, and they want a list of which devices were active within it. So to me, it's very likely, although I don't know, that the feds would have got this just as a matter of routine when they issued those subpoenas. They would have also got some geofence data of what? Well, they would have certainly started out with getting geofence data of 34 Fairview in those time periods, but they could have got a lot more. It depends on how aggressive they were. They could have also got for instance, geofence data of Chris Albert's house to see what time calling got home. They could have got geofence of the McCabe house or of potentially the Canton police station. I don't know, Now, they would not be required to hand over evidence that would clear the suspects falsely accused in this case. They are required. They are legally required through Brady versus Maryland and through the same law that led to the TUI process. They are legally required to turn over exculpatory evidence that's material to a defendant. Now, the only defendant in this case is Karen Reed. So the only exculpatory evidence that the feds were required to turn over were, thank you, Catherine. The only exculpatory evidence that they were required to turn over was relevant to Karen Reed. Anything that might help show her innocence. Anything, even does not prove her innocence, but just anything that she could use that might be material. So, for instance, if they had geofence data that showed that Colin was in the house at 12:30, that would be huge. They would have to turn that over because that could potentially be used by her defense team to defend her. And the way that process works is one of the parties, either the prosecution or the defense team, files an official request with the federal government for that information. And once they do that, the federal government has no choice. This is something that Sean McDonough and other people have not understood. And too many people in the free Karen Reed world don't understand. They still think the feds are coming. No, they're not coming. And they couldn't have withheld any of that information. A friend of mine, one of my best friends from college, is a judge in another state. And he kind of said the same thing. No, the feds move at their own pace. No, it's Brady versus Maryland. They have no choice. It's what I've talked to lawyers. I've well researched it now. They have no choice. It's the law. And so if they withheld any exculpatory evidence for Karen, they're in violation of the law. That's just a fact. And so that TUI now, DA Morrissey had, through his letters, at least through his letters, perhaps through other, had officially requested this information several times. So that should begin the TUI process. And then, but formally, we saw several months ago the actual the letter from Karen's defense team. I think it was signed by Alan Jackson, but probably the whole team. But their formal request for any material evidence. Now, once that happens, the feds put everything that they have through what's called the TUI process, which determines what they have to turn over, which again would be anything exculpatory to a defendant, and make sure that everything complies with federal rules on sources and things like that. So there's a process there, and it's called the TUI process. But they have no choice. But the thing is if they have something that exonerates the witnesses, they have no legal obligation to turn that over. But there are other obligations. So the Federal Privacy Act entitles people with standing to if they ask the government for that information. So, for instance, if they are not indicted and they ask the government for any affidavits that were filed relative to them, where they're the subject, then my understanding is that the federal government will have to turn that over. I don't know how long. I don't know what the process is. That would be a different process, I assume, than the TUI process. Very different. I don't know how long it takes. These are what you need, lawyers that specialize in that kind of thing. But this is if the feds have geofence data, for instance, that showed who was in the house, and it proves, as we now know by other evidence, that Colin Albert had left sometime around 12:15, maybe as late as 12:20, something in that area. But he was gone by the time Karen and John arrived. That doesn't mean that what the feds did was illegal, but what it did was highly, highly, highly unethical. You can't do that. You're sitting there just to cover your own ass because you're embarrassed about a bad investigation that you launched, and you're going to let innocent people be destroyed for you. That's what I mean about integrity. Means you have to risk something. You have to be willing to lose something to do the right thing. Otherwise, it's meaningless. So Josh Levy seems to have been in that position where at some point he realized and the people working immediately under him, that what they did was a dead end. They were duped, and it hurt innocent people. Now, for reasons that have to be uncovered, they allowed that to go on. Now, the simplest explanation, and I'm going to get to another really excellent article in a moment by anonymous mass lawyer. That's like come early, so I was going to go on even earlier, and then I had a call relative to information here, so I'll get back to that. But at the very least, the U.S. Attorney's Office were embarrassed and tried to cover up that embarrassment by keeping the investigation falsely listed as ongoing in order to hide it. But there's a lot more. The fact that they were communicating with Dr. Wolf, violating sequestration order during the trial, and all the other evidence of improper communication between Karen's defense team and people from the U.S. Attorney's Office, including Josh Levy himself, there's much more going on. And then, as I've said many times, the fact that they used Turtle Boy's article in their questioning of the witnesses, and Turtle Boy won't brag about it. There is something going on here, and we need to get to the bottom of it. And I don't, a lot of times, people will say, well, what are the chances of someone coming forward? What are the chances of someone in the media taking this up? They're always against the odds. But at the end of the day, when something is exposed, when wrongdoing is exposed, at the end of the day, it was always through some unlikely source. So yes, we're barking up something that's a little bit unlikely here. But at the end of the day, that's always how it works, is somebody with courage that you didn't expect stood up and did the right thing. All right, let me go see if I can get anonymous articles. He's making such a contribution with his articles. Let me share it on the screen so you guys can see it too. This is another excellent article. The clarity he's bringing I've been so discouraged by the legal profession over the last year. So to see this, the clarity of thought is good. All right. So he says, as I noted on Twitter, so he's speaking about yesterday. Today was an unmitigated disaster for the defense. Alessi's cross-examination of Welcher wasn't just a waste of time. It was full on counterproductive. He gave Welcher the opportunity again and again to show that he was much smarter than Alessi and to expand upon areas of his analysis that he only touched on briefly in his direct examination. As a defense attorney, you never want to give a prosecution expert a platform to dunk on you and further flesh out their analysis. That's exactly what Alessi did all day long. And you guys saw that better than me. I had to leave to go to Boston. I've watched some of it on replay, and yeah, it was pretty powerful. With respect to the substance of Welcher's analysis, a few things worth noting. Welcher substantively disagrees with Trooper Paul about the significance of the text stream data. That turns out to be true. Is this a problem? Paul testified at the first trial that the momentary drop in speed 4 seconds into the reversal event, despite no easing off of the accelerator, was a telltale sign of a pedestrian collision, which would mean that John was hit as the vehicle was still going at nearly 24 miles an hour. So I've talked about this many times on the channel. I accepted Trooper Paul's analysis. Kate has too. And the two things that we looked at that Paul highlighted was the drop in speed, which was only 0.6 miles an hour, and the shift in the steering wheel from minus 4.5 to plus 4.5. But it turns out there's another, according to Welcher, there's another explanation for that is, and this is not the telltale sign of a pedestrian strike. That's an issue that's separate from this trial. That is troubling because you have someone whose life and liberty is in your hands and you're the expert. It is troubling that the state would put up an expert that would report something like that turns out to be not accurate. Now, Trooper Paul's honesty to me is beyond reproach. This guy is an honest, good cop. But those kind of mistakes shouldn't happen. So maybe Paul was correct. Maybe Welcher's got it wrong. I don't know, but it is troubling. Welcher testified that this drop in speed was due to the SUV's wheels spinning in the snow. He did not offer an opinion as to precisely when. It's so funny. I floated out the wheels spinning in the snow story like way back in the summer of 2023, and not just me, other people too, just as a possibility. He did not offer an opinion as to precisely when relative to the trigger event. Now, again, the trigger event, people get confused on that. Vinny gets confused on that on Court TV. The trigger event had nothing to do with the collision. There was no recorded collision. Even Trooper Paul didn't. The system itself was not triggered by the detection of a collision. If it was, the black box, which is a separate recording system in there, would have recorded something. It didn't. And it typically, Dr. Wolf from ARCA testified that it typically does not in a pedestrian strike because of the size differential between the vehicles, between the objects. And the trigger event was when the car was in reverse, and the accelerator was hit over 30%. So the algorithm is set to say, all right, hitting the gas over 30% while in reverse is something weird. Let's take a snapshot here. That's just the settings of the algorithm. All right. So Welcher did not offer an opinion as to precisely when, relative to the trigger event, the collision took place. But I think if you read between the lines, he suspects that it happened after the trigger event data elapsed and likely after the vehicle had begun to slow down somewhat. So what this means is, so when you get the trigger event, so in this case, it's the moment that the algorithm detects the car in reverse going more than 30% on acceleration, that at that moment, a snapshot is created. Now the data's been recording continuously, so that snapshot goes back in time 5 seconds. So it records 5 seconds of data before the triggering event, as well as 5 seconds after the triggering event, but only 5 seconds. So if it doesn't go beyond the 5 seconds before, and it doesn't go beyond the 5 seconds after. So what Anonymous is saying here is that his understanding of Welcher is that the accident when it happened would have been beyond the collision when it happened would have been beyond the 5 seconds. That's what he's saying. So it was beyond the data, and we don't know when Karen braked. Within that 10-second snapshot trigger event, there is no indication of her ever hitting the brakes. So presumably it would have been not long afterwards. She didn't drive home in reverse, but there's no indication. He testified that it only needed to be moving at 8 miles per hour for the taillight to be broken. And I rewatched that testimony last night too, and also the cross-examination of it. And unless he was trying to establish somehow that there would have been a broken bone, and I thought Welcher parried that off very well. The wiggle room that Welcher left for himself may end up helping when he's called back as a rebuttal witness. So this again, and Anonymous will hit on this later too, but how much of this involves Hank's strategy of leaving something on the table to come for redirect and possibly even the rebuttal, which will come after the defense presents their case in chief. All right. Relatedly, because of some of Trooper Paul's errors, misinterpreting the key cycle, mischaracterizing the wheel spin out the moment of collision, Brennan has gone to significant effort to insulate Welcher's analysis from Paul's. And that was something that Alessi was trying to do yesterday, to attach Welcher's conclusions to Paul's, and so that, in other words, saying that they weren't independent, Trooper Paul's. He clearly did not want to have to call Paul as a witness. This is what the voir dire was about at the end of the day. Alessi is trying to assert that Welcher relied on Paul's analysis, Trooper Paul's analysis, so that he can cross-examine Welcher about some of Paul's errors. I don't think he's going to succeed on that front, says Anonymous, and even if he does, it may be a bit of a Pyrrhic victory. I don't think the jury is going to care that someone they don't know made some errors, and it will just give Welcher the opportunity to look smarter and more independent. That's a key point. Welcher really tried to make a case yesterday that his conclusions were independent. He took a fresh look at the evidence and data. I thought he did a good job at that, and Alessi was trying to undermine that, and I thought he failed. There's another aspect of Welcher's testimony that is causing a lot of confusion. In his model of the second trigger event, he showed how the SUV moved forward over 30 feet before reversing almost 80 feet. The FKR Twitter world has taken this to mean that the vehicle ended up over 50 feet past the flagpole area, where they claim it should have collided with Higgins' Jeep. Well, this is a good point, and they spent a lot of time on this yesterday. So I believe that Welcher has concluded that the car went at least 89 feet in reverse. However, some of that was recapturing the territory that it had gone forward. So it went forward 34 feet, something like that. And then when it went backwards, that's just regaining the territory that it just went forward. So ultimately, the distance that it may have gone backwards might have been like 59 feet or something like that. Now, I can tell you from doing Google measurements of this that, if I remember right, I believe the distance from the flagpole to the driveway was about 70 feet. So you could go backwards from the flagpole 59 feet. And if a small Jeep or something, or vehicle was parked at the near the driveway, near the mailbox, you wouldn't have hit it. So there are different possibilities here. So he goes on. This is a total misreading of the data. The 10-second trigger event is a snapshot. It captured only a few seconds of forward motion, but when it started, the SUV was already moving forward at 13 miles an hour. We don't know how far it had traveled before that. So we don't. That was the testimony yesterday. Welcher was explaining we can only calculate it and estimate based on the speed because we do know the speed and the time that it went that speed. We don't know how far it traveled before that, but clearly it was enough distance to have reached that speed. The most likely explanation here, which is consistent with Matt McCabe's testimony and Karen's own statements, is that Karen pulled forward 70 plus feet from the flagpole area before she stopped, went into reverse, and ultimately ended up not that far from when she started. I don't know if that's true. I mean, I don't know if that's what Welcher's saying. I'm not disagreeing with Anonymous here. I just don't know myself if that's what he's concluded. And I don't think I'm not even sure if Welcher's conclusions were that specific. I think what Welcher is trying to do is create a window and that this happened within this window. And we don't know precisely where Justin started, that kind of thing. But there was certainly room within that window for the things to happen that the state says. There's no reason to assume he says she went further in reverse than she did forward. It's just that we only see part of the round trip journey in the 10 seconds. Overall, I think Welcher has been a very good witness, one who has done even better on cross-examination than he did on his somewhat perfunctory direct. It's kind of weird, right? I had the sense that Brennan moved fairly quickly through his direct examination and did not take as much time as I would have. Again, I'm reading for Anonymous. He's obviously a trial lawyer to dwell on anything or allow Welcher to flesh his analysis out. I'm not sure whether that was intentional strategy by Brennan, perhaps to reserve some areas for redirect, which does seem to be what he does commonly, or even in rebuttal, and whether he was just a little impatient. It doesn't seem like impatience would likely be it, but either way, I think that there were some people on both sides of this case who were expecting to hear more, who were expecting Welcher to offer a very specific hypothesis as to the exact mechanics of the collision, complete with 3D modeling or an actual demonstration. I certainly was hoping for that. I'm not saying I'm disappointing might be a little too strong, but I understand why it makes sense. And I thought Welcher was very upfront in saying there's just certain variables here that are unknown, and you don't have a witness and you don't have video. So, but I had hoped they'd be able to get more from the data and the physical evidence, but if they can't, they can't. So he goes on, I've been trying to manage people's expectations on that front, and Anonymous has been doing that and successfully. The reality is that this was a hit and run with no witnesses, and there are far too many variables at play to be able to construct that kind of detailed recreation of the event. And that's true. Welcher did a good job. You don't know where was John standing, where was he leaning, what were his exact movements. John, Nick says on Court TV strange things like, why would somebody just be standing with their arm out? Nobody said that, Nick. Nobody thinks that. You don't know exactly what happened. You're walking along the road, and suddenly you realize a vehicle's coming towards you, and you turn. You got a drink in your hand, so your arm is bent. You're drunk. There's a variety of things here that affect the position you're going to be in. No one is saying he was standing out there hailing a cab. It's ridiculous. Welcher and Nick is prepared by Karen's defense team, so this tells them they don't really have much. That's all. That was the talking point they gave him, knowing that was the show. It's empty. All right, Welcher, to his credit, has been very straightforward with the jury about that reality. There is simply no way to know the precise speed and angle that the vehicle hit John. There's no way to know exactly where he was standing or the exact position. I guess I'm repeating what he's saying when I said there's no way to know he's standing. There's no way to know his movements. He may have tried to make to keep from falling. What's important is the totality of the evidence, as Welcher repeatedly explained. There is no question that Karen's vehicle was traveling at a ludicrous speed in reverse moments before John's phone recorded its last movement. Now, to be fair, free Karen Reed, you have to ignore that. You have to ignore the fact that the defense has not been able to challenge that at all. So I don't know if Tyler is here. Tyler, you can't just ignore this stuff because you want there to be something suspicious here because cover up is way more interesting, right? But you can't just ignore fundamental evidence. I'm sorry. There was taillight debris found at the scene, entangled in John's clothing, his DNA and hair. So yeah, the totality of the evidence that we've all talked about here. Anonymous says this is an incredibly strong case. It's more than enough evidence to rule out any other reasonable theory that could have happened. And this is the key. We're not going through this. There's kind of two approaches to a case. There's whittling down the evidence until it points specifically to something. which is what you would do if you had a direct eyewitness of it or video. But the other way is the Sherlock Holmes method, and the more common one. You eliminate all of the possibilities until only one remains. And this is what the accident reconstruction has done. This is what Hank Brennan has done effectively. You eliminate all of the possibilities until the only thing that remains is that Karen driving that Lexus struck John just seconds before his phone last moved. His last paragraph, he finishes, what Welcher's testimony does more than anything else is give the jury the comfort to follow their own common sense. That's an interesting idea. He's a very smart, well-educated guy with highly relevant expertise, and he's considered nearly all of the same evidence that the jury has. By tying all of that evidence together and expressing a confident opinion as to what it all means, he's giving the jury the comfort of knowing that their own intuitions are correct, that he sees everything the same way that they do, and is comfortable putting his reputation behind this conclusion. That's what a good expert does, and it's why Karen Reed should be very concerned. And I think that's true because if you just even listening to the way Ronnie, the juror, was talking about how this stuff played out with him, the jury was looking at basic evidence. All right, you have an accident. You have the defendant was there and she's drunk. There's no question about that. She left him there. There's no question about that. What are the options here? And that's the beginning of that process of whittling down all of the options. So I think I wish we saw those kind of arguments being made on TV, not just court TV, but the local channels. We're not seeing that, and it's a source of endless frustration to me and to others. Why does some guy like me with no law degree have to be the one to step up and make these arguments for the last 2 years? Why aren't there smarter people, more capable people with history? Joe Krauske has been such a great addition to this. But why aren't there more Joe Krauskes out there? It's frustrating. It shouldn't have to be me. I should be out there going writing my stupid ghost stories in fiction or whatever. I shouldn't have to do this. But what we're learning here, including you guys there, we all have to do what we can. And you don't want to be in a position of looking back on this case. Let me bring in Jen too. Look, we don't want to be in a position. Oh, Jen was here and we lost her. We don't want to be in a position of looking back on this kind of momentous moment where there's a moral dilemma of our time, at least locally here, but even to the extent that this case is covered nationally, and say that we did nothing. We don't want to be a year from now, 2 years from now, 5 years from now, be looking back, seeing what we know is wrongdoing, watching innocent people get bullied by a mob, by a friggin' mindless mob, watching a murder defendant in this alliance between YouTube creators that want to exploit this for their own benefit, and most importantly, the federal government that wanted to exploit this. All not just to get Karen off, but to victimize innocent people who did nothing wrong. Do you want to be in the position of a year from now looking back and say you did nothing? No. Now, there are different things that people can do. Not everybody most people can't go out and start their own channel, obviously. But you know what you can do. You can find a way. You can write to the U.S. Attorney's Office. You can write to the Boston Globe Spotlight team and say, look, this needs to be looked into. That's what you guys exist for. This is wrongdoing. And so maybe people can organize it. Maybe somebody here can help organize that. Do something. Don't just stand silently back. This is one of the, like I said, the moral dilemmas of our time, where people are being bullied and destroyed. You can see the way this mob acts. It is truly mindless and it is truly cruel. They enjoy what they're doing. Taking pictures of Jen McCabe and Chatham. It's just unbelievable. It's cruel. It has no place in justice. And pretty much everybody that is here understands that. And so my challenge to you is, what are you doing to have an impact? What are you doing to make your voice felt? Even the Free Karen Reed people that are out there demonstrating, at least they're doing something. So I'm not trying to guilt you. I'm trying to tell you, this is how you look in the mirror at yourself a year from now. You're going to say, why didn't I do something? So, and some people are in a position to do more for, you are. whether you're a lawyer or whatever. Do it. Do it. Don't you, this is a great injustice that's going on here. There's wrongdoing, but everybody knows what they can do, what they can find a way. It has to involve some risk. If you, again, I said this is things like integrity, they involve risk, they involve courage. If it's easy, you didn't really do anything worthwhile. So let's get to questions. And Jen popped in for a second, but Jen, I think she'll be on. Jen is very busy from 8 to 9 with TV shows and stuff like that. So Jen is she's doing her part, and Jen's been doing her part since early on. She was one of the first to appear on shows with Wendy Murphy going back, like, I don't know, in like May of 2023. So Jen is fully doing her part, but hopefully we'll have her here this morning. I know Kate will be here. She had errands or something to take care of this morning. So, but don't worry, Kate, we'll be back. I like they did such a good job with me in the hospital and stuff that there's probably people sitting there like, all right, shut this guy up. We want the regular panel back. That when I was gone, there were people, I'd be in the hospital just quietly watching, and people would say, "Who's this guy, Kevin?" So, so maybe if I come on early in the morning and make my voice say my bit then, and then I can let step aside and let other people go back to our regular programming for the last few weeks, as they might say. Catherine, thank you. She says, love the hard work you're doing, and we appreciate having a great live chat to join every day. And that is why I was really grateful to have Kate keep it on this channel, because Kate has her own channel, and obviously Matt and Jen do too. Just most of us were here on this channel during the first trial, and they were here with us. And so I thought it was good to have it in the same place so people wouldn't be kind of scattered and lost. So that was why I put my channel in Kate's hands and her very capable hands, and they did a great job. And so, but that was why I did it. Julia Gulagulia. How do you write that name? Damn. Kevin, you have integrity and it shows. Keep up the good fight. Oh, Jen is back to save the day. Good morning, Jen.
Hi, how are you? Oh my gosh, I'm having so many computer problems. I'm sitting here with a phone in my hand. I've got what is this? A Lenovo on one side, a Hewlett Packard on the other. My husband's going down and getting my Mac because I'm having trouble with StreamYard. How are you this morning?
I always try to reboot right before the show just to make sure like everything is clear. Reboot the computer that I'm using.
That's what I'm doing right now, the computer. So I'm just on my phone right now. How's everything?
Everything's good. Everything's good. I don't know if you heard my long-winded sermon, but there was another great article by anonymous mass lawyer, and he or she, and I have private communication with him over email, but I have no idea who he is or she is. But they really brought so much clarity to this case. I wish there was more of them. I wish there was people like that on TV more. But excellent articles. I don't know if you follow them at all. Anonymous mass lawyer.
I think so. I think I saw them pop up, and I read something and I really liked it. And I remember saying, like, I also like Tuesday Gazette or the overall just kind of what happened each day. She does a great job.
Fantastic.
For me, I have to listen because even if I'm not on in the day, I listen at night, I listen in the car because I truly want to have that, that knowledge. I'm so
you're not getting it translated. You're getting it direct, right?
Yeah. And it's so irritating. Last night I was on about, the Karen Reed case, and I was on with an attorney, and it was clear to me he's not watching the trial. You have to watch the trial. I don't want to say that if you haven't watched the trial, you can't have an opinion, but it's not going to be as well educated. And there were a couple parts that I hadn't seen yet. And so I was catching up with Kate on two very specific points that I wanted to have clarified. Because, I mean, look, the judge allowed the expert to make their opinion on whether, based on the totality of the evidence, that Karen Reed's, and he couldn't say Karen Reed's SUV, but that SUV, just like Karen Reed's, hit John O'Keefe. And he said that at the end. He made that crystal clear. That was his summary.
Right. Yep, absolutely. And I agree with you too. It's been a source of frustration for me trying to trying to get these. So last year I did attempt to do a recap, but it ended up being too much covering the trial all day, trying to write notes for a recap, and then going on court TV at night. It was too much. And so me and Kate had talked about the need for it before this trial too, but it's just so time consuming if you're, especially if you're streaming during the day. So we're all relying, not well, we watched the trial, but I think I had to miss parts of it because of my health issues. And so I rely on Tuesday too to go back and get that summary. I don't know where else you can get it. She's the only one kind of doing it and trying to do it objectively. So, but yeah, I wish there was a more detailed. I had plans that I didn't have time to. You can use a program called Notebook LM. It's a free program, a Google AI program, to get a pretty detailed synopsis of what happened. I just haven't had time to make that part of what I'm doing because of all the other issues. If I hadn't been, if my health hadn't gone south the last couple of months, I would have been doing that, and we would have that AI to the rescue. But I don't know. I guess we're stuck with what we have. But we do get, because of Kate and Boomer and Matt watching the show, I can at least talk to them or come and tune at the end and get a good summary of what happened during the day. They give a pretty good idea.
Yeah, and I think what happens though with all of these experts is there's a propensity to get caught up in, and Alessi's doing it, and I think many people are doing it, sort of the minutia
Yeah.
instead of getting caught up in the conclusion.
Right.
And at the end of the day, he has to give the minutia to lead to the conclusion, but you can't parse it out and say,
Yeah.
well, he said this word or that word. You have to look again at the totality. And I always go to the conclusions, even if you have an expert report. I don't
Mhm.
know how long his is. I mean, I think his is over 100 pages, it sounds like.
Mhm.
And it's great to read the whole thing, but especially I'm not an engineer. So for all those calculations he's doing, and you're exactly right on the total 80 feet, which I couldn't tell whether Alessi just didn't understand him. He probably had him repeat it 4 times.
Yeah.
It's so easy. Listen, she went forward 30 something feet, and then she went back a total of 80, which, as you said, recaptured the 30. And so they're not at the flagpole. These are such easy concepts, but people get caught up in the minutia of numbers and don't look at the totality. At the end of the day, that was his conclusion, and that's what I'm going to look at as a juror.
He was so clearly trying to be deceptive, and because he wants to get to the point where he can say, or somehow try to trick Welcher into saying that the car went in reverse 80 feet or something like that from the flagpole, and that would put them in the vicinity of Higgins' Jeep if it was said to be parked. But that's why he needs to get to that 80 feet. But if it's only 50 feet, no, because the distance from the flagpole to the driveway was 70 feet. So there was plenty of room for Karen to pull forward 34 feet or whatever it was, and then go backwards 89 feet, which would be a total of, say, 50 something feet from the flagpole. And it's an impressive bit of driving that she got lucky, I guess, but it is what it is. That it's just what the data shows, Jen, one thing. Oh, Jen booted herself. Let's see. Are you back, Jen? Oh, so I've got you in, and I know Jen's
Yes,
having technical
I'm
issues
trying to
when
get
she
in
talks.
on my
So
computer.
that's okay. Take your time, and when
Can you hear me?
you're back, you'll talk, and I'll know. I can hear you. Yep, we can hear you good.
Okay,
So I got
perfect. I'm back in on my computer now as opposed to.
okay. So I wanted to talk to you about this. I mentioned this
Yeah.
yesterday, and I'd be interested to hear your thoughts on this. So just kind of something that was occurring to me yesterday. 2 general approaches to solving a case, or to, and like proving the charges. On the one hand, one approach is you're laying out all the evidence that points directly to what happens, but a different approach is the kind of Sherlock Holmes approach, where you're eliminating all possibilities until you have only one left. And so I think that the Trooper Paul approach was more the first one, but it turns out that some of his key analysis was wrong. And the Welcher approach is, I'm going to eliminate all the possibilities until there's only one, and that occurs within this window. So I don't know exactly what time John was struck. I don't know where exactly or where he was standing or what he was doing. But this is the only possibility. I don't know. Can you respond to that? Does that sound sensible the way I just described that?
Yeah, I think, and tell me if is my
I hear you.
am I breaking up a lot?
No, not at all, actually.
Okay, good. You're breaking up a little. That's why I was asking, but I think it's
Oh,
my computer. Uh, when you go into an investigation, you literally are following bread,
yeah.
but the
That broke up a
breadcrumbs
little bit, but yeah,
can
go ahead.
be, all right, you got pumpernickel breadcrumbs, you got wheat breadcrumbs, you got white breadcrumbs, right? There's different
Yeah.
breadcrumbs at the beginning of a case that can go into different areas. And that's where the elimination starts. When you're going down a road of breadcrumbs and now it's not lining up, it doesn't make sense. It's illogical. There's no proof of it. Then you get
Mhm.
off that road and you head to the next road. So in that way, it does become a situation where it's the process of elimination, so to speak, but it's the evidence and the clues that lead you to your conclusions for sure.
Right. 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 So it is kind of a different thing here. So Welcher is not giving them specifically what or when. He's leaving it. He's narrowed it down to a very tiny window where there's no room for anything else. And that's a different approach than last year, but it leaves him some flexibility too, where once the defense comes out with their experts and they start challenging, they don't, he can say, well, this is all within the window of what we said happened, and nothing else is. I don't, and it seems like maybe now the defense is trying this weird idea where I don't know, Karen damaged her taillight on Higgins' Jeep. Is that something weird like that? I don't know. I don't know how they mesh that with the idea of John going in the house, but not sure if you might have broken.
Well,
I
he's
don't
an
hear anything.
engineer, and those
Oh,
types never say anything is perfect.
good point.
Good. Ah, dang it. All right. I'm going to get my good
I totally
computers here because my
sympathize.
husband went and got it.
Okay, I'll let you do that. We'll just let Jen come in and out as she can, as she's fixing things. And I totally sympathize with her plight because these things can be problematic. When I'm set up in my studio, I've got a few computers going, and one of them is going to get hot, one of them's going to do this. You try to reset them all before the show, but unfortunately, technology is, Kate's much better with it. Maybe Boomer too. Good morning, Boomer.
Good morning, Kevin.
How are
Hello,
you with the
everybody.
tech stuff? Are you a good tech guy, or are you someone that gets frustrated like me?
I'm sort of a little bit okay, a little bit not. If it's something I really need to learn about, I'll go deep into the tutorials and I'll figure it out. But I'm very reluctant with tech. I don't prefer to deal with it, but I'm all right.
Right.
I'm all right.
Yeah.
Unless it's
get-
Streamlabs, then I apparently I haven't figured that out yet. The audio on that's crazy.
Yeah, that was the one that Kate was trying to use, right? I remember I was on a couple of shows.
Yeah.
It seemed to be a cumbersome or problematic kind of thing.
Yeah, we haven't figured it out yet.
So Frank Perry says, so one thing I saw in yesterday's testimony is Alessi kept asking about emails, and he kept bringing up all the troll emails he's been getting. I don't remember that, so do you have any memory of that or any thoughts on that?
Alessi kept asking about emails, and he kept bringing up the trolls email. I recall one statement that was made about a troll in an email, but that was it. I don't recall it being brought up more than once, and I don't recall it being delved into. It was just excuse me, it was just mentioned.
It's weird. I wonder what that would what context that would be. I mean, is he getting threats? I don't even understand it.
Well, I mean, with this case, right? At this point, I just assume any and all people involved with this trial in this case, if they're not free Karen Reed, they're definitely getting.
Well, he's a lawyer, so but yeah.
No, I thought it was well, I might have had it wrong then. I thought it was Welcher who had the email.
You might be right. I'm just going based on what Frank said. I don't remember any of that yesterday, so
I could be up. Excuse me. Like I said, I just remember it was very quick, and it was one mention. I thought it was Welcher. Because that's they go and they find their Google advertisement and they downvote it, and they go nuts on trolling everybody and anybody. Yeah, Welcher got the emails. I figured, but I didn't think they really got deep into it, though. Just kind of mentioned it. But yeah, it seems like everybody, no one's removed from that. The judge, everybody's getting harassed, man. Yeah. They have no shame. Mm-hmm.
I had one night, Tom CPU said he was on his way to my house. This was like at midnight.
Oh, God.
Like, what the hell are
Isn't
you gonna
that
do, Tom?
creepy as hell? Oh, creep you out? Guy is warped.
Yeah.
You know what I feel like with these people sometimes is that these were the same people that watched The Guiding Light and All My Children and would get so angry and say, oh, I can't believe Tom just cheated on Susan, or can you believe that Gary just sideswiped Harvey and he's dead, or whatever. And they were so mad and worked up, and their whole lives were these soap operas. And they forget, I mean, I really think these would be those people back in the 60s and 70s and 80s when you didn't have true crime like this. And they forget sometimes these are real people and real
they do.
lives. And they act like this is a television show, and it's far from it.
Yeah, this is their entertainment. Absolutely.
Yeah.
I believe that fully.
Yeah, I've noticed that from the beginning, like how obviously some of the cruelty these people enjoyed the harassment of the witnesses, and some of that is just they're cruel by nature. But I know people that maybe went a little bit down that road that are not cruel by nature, and I think maybe it's for the reason Jen just said. They're just somehow forgetting that those people are not characters in a movie or in Game of Thrones. They're real people with real lives, and they have kids, and they have parents, and they have problems like everybody else. And I think there's that blurring between reality is definitely a problem. It's good to remind us of that.
I've been referring to this whole deal with from their vantage point anyway, is like trial 1 was season 1, and they didn't get the season ending they were promised, right? They were promised initially that Karen wouldn't even go to trial.
Right, and the feds were going to swoop in and arrest everybody.
That's right. That was the promise for season 1, right? And they said that's just what's going to happen, because everything was like an entertainment-based narrative, like Jen, like pointing out, like it's a soap opera, and then it went to trial, and it was like, well, don't worry, folks, because it's going to be an acquittal, and everything was treated like it was entertainment, and it still is. Right. It's an interactive entertainment,
Yeah,
you don't want that to go away. That's why when you challenge Free Karen Reed with logic, they flip out, because what you're doing is you're taking their entertainment away, and you're taking away their interconnectivity, their friends they've made.
Yes.
They often say.
Yeah, and in some cases, their whole identity.
Melanie Little calls it season 1 and season 2. No way. And there you go. She's just nakedly saying it. Like, that's how they see it. That's warped.
You are unmuted.
Some of these people, like certainly Turtle Boy, but I would say a lot of them, they fully understand they're peddling BS, but they're just they're willing to do it because they're benefiting from it personally.
Now open and be seated.
All right, let's see what kind of sidebar we open with.
Yeah.
Well, there will be a ruling.
All right.
So.
Good morning, counsel. Good morning, Ms. Reed. And all right, Mr. Lessie, I will hear you on your argument on the voir dire.
Thank you, Your Honor. I'm just loading up my computer. Your Honor, I am going to address the Trooper Paul aspect, and then I'm going to address the Dr. Scorti Bello aspect of Dr. Welcher. With regard to Trooper Paul, I would like to draw the court's attention to the following documents for the straightforward proposition that Dr. Welcher has not only reviewed, he has not only considered, that he has adopted. I went back and looked at the documents, and the basis for this is as follows. Slides 22 and 23 do not just depict Trooper Joseph Paul himself they show Trooper Paul conducting the CARS analysis on February 1st of 2022. Importantly, these slides highlight the mileage odometer of 12,665, and I respectfully request the court to anchor into that odometer reading, because I'm going to show the path that that odometer reading takes through all of the documents, but I want to emphasize the start, the genesis of the odometer reading of 12,665 miles is with Trooper Paul as he conducted the CARS analysis on February 1st. Now, here's where Dr. Welcher comes in. Dr. Welcher then uses this key data point, odometer 12,665, as the basis, the starting point for his determination of the locations and times for the events of January 29 of 2022. Dr. Welcher uses his scenario analysis of Miss Reed's travels, and that's detailed on slides 24, 25, 26, 27, and 28, to calculate and then deduct 36 miles from the odometer according to Trooper Paul on February 1st of 2022 to arrive at an odometer reading of 12,629, which obviously is different from the start, the anchor I talked about of 12,665. So the assumed odometer of 12,629, again, is based on Trooper Paul's CARS analysis in slides 22 and 23, are then used as a tether, a connection to the events recorded by the VCH in the Lexus on the following slides: 28, 29, 30, 31, 32, 33, 35, and 36. I elucidate this and I explicate the slide numbers to show how many there are in Dr. Welcher's report that are rooted in the anchor point and then the change in the deduction of the odometer. So the events memorialized by Trooper Paul on February 1st, including the odometer reading, provide the foundation for Dr. Welcher's entire analysis of the VCH events. The entire analysis of Dr. Welcher's VCH events. That is the adoption aspect of what I started with. Two more points. In addition, Dr. Welcher testified on his voir dire that the image on the left of slide 36 from his January 30th, 2025 presentation came from a file marked carsj.paul. Now, he did contend that it wasn't the exact same image, but I want to go to this. In fact, the image on slide 36 is from the drone used by Trooper Paul, and the citation for that is page 4, item 11 of the CARS report. That's where the drones are from. Dr. Welcher didn't do any drone activity. He took the drone that he had in his report that was just a little bit different than the one I was showing him. It comes from page 4, item 11 of the CARS report. And I quote, "The crash scene was documented during the on-scene investigation by utilizing Alicia's GNSS GPS mapping system and a DJI Mavic 2 UAS. This data was input to a computer-aided diagram program, which is IMS 360. Here's the key: to produce a scale diagram of this collision. So the DJI Mavic is the CARS team drone. This image of Dr. Welcher's slide 36 is clearly and indisputably from the drone. And the only drone extant is the drone of Trooper Paul and the CARS team. Last point with regard to the Trooper Paul basis in adoption of Dr. Welcher. Mr. Brennan asked Dr. Welcher on voir dire if the image from slide 36 actually came from the CERT team, which is simply not true. The CERT team, actually Lieutenant Tully with the CERT team, took about a dozen photos of the taillight in the snow in the dark around 6 p.m. on January 29, 2022. Lieutenant O'Hara said that the CERT team never traveled back to the scene again. So there were very obviously no photos or images taken by the CERT team in the daylight from the drone. And I again refer to slides 22 and slides 23, where Dr. Welcher said it was more likely than not that it was Trooper Paul in those slides, but the point, whether it's Trooper Paul or not, is completely overwhelmed by what I just argued and presented as specific factual basis for a review, a consideration, and an adoption of the work of Trooper Paul. Unless your Honor has any questions, I would now move on to Dr. Scorti-Bello. Thank you. Dr. Scorti-Bello will be much shorter. Mr. Woke, do we have the slide of the Dr. Scorti-Bello it's at the end of the slide presentation with her name on it? Oh. You just give the slide number, please. So it is slide 131. I almost know it verbatim, Your Honor, so I will continue. If Ms. Gilman has slide or someone could turn it on. Okay, thank you. Thank you, Your Honor. So with regard to slide 31, at the very top, and this again is a slide presentation of Dr. Welcher. So up at the very top, and so Dr. Welcher admitted that he not only reviewed the autopsy report, he admitted that he not only considered the autopsy report, he admitted that he adopted it, and I'm going to put adopt in quotes, to the extent that he used it in his slide presentation, and he actually, to show the depth of those three verbs, he's got in orange highlight under final diagnosis, multiple skull fractures, base of skull, and cavallarium. He testified, obviously, about the rear wounds of Mr. O'Keefe. He testified about how he believed those wounds came about, and he cited as corroboration the highlight of multiple skull fractures, base of skull, and cavallarium. It couldn't be any more obvious, his rooting in this document and reliance upon it. Why else would he have it in his slide presentation? And he's got the name of Dr. Scorti-Bello. And frankly, Your Honor, he didn't fight that whatsoever in the questioning of him. Then you go to underneath cause of death, blood impact, injuries of head, and hypothermia. He essentially repeated that on his testimony. And then if we could, Mr. Wolk, just go to the right. And so you've got highlighted head, skull fracture radiating from the right occipital skull. and into the right parietal bone, right and left occipital foci, and bilateral anterior foci and orbital plates. Again, the highlighted means something. He's adopting it. And lastly, that the depiction of the skull here, I believe that's Dr. Welcher's handwriting. I believe that's his green, the LR, because I've never seen this green highlighting before. And it could also be Dr. Scorty Bellows. That's another possibility. I'm not sure. But let's assume sort of the most conservative part that it's Dr. Scorty Bellows. The key part is he's got it in there and he is referencing it. So, Your Honor, the last point really for both of them, and I wanted to save this point because it applies to both. With regard to experts, the law is clear. So I think the easiest part to show what our position here is the adoption. But in it, it's clearly shown. Adoption doesn't mean you have to agree with it. You just have to put your expert hands around it, wrestle with it, deal with it. And there is no rule of law that I'm aware of that says you can't question an expert witness unless it's something that the expert witness agrees with. If the expert witness has reviewed it and considered it, and especially if they've rejected it. The easiest is obviously reviewed, considered, and adopted. But it's certainly permissible and important to a defendant's constitutional right, Sixth Amendment to cross-examination, if an expert says or even infers, I reject this. I reject what Trooper Paul did, or I reject what Dr. Scorty Bello did. That is decision-making of an expert that the attorney has a right to be able to test. Why did you reject it? What was your thought process in rejecting it? And that applies to both Trooper Paul and Dr. Scorty Bello, because as I understand it, this witness, Dr. Welcher, is not, he says, I'm not relying upon Dr. or Trooper Paul, which is completely false based upon what I just showed. But even if he just rejects it, in addition to what he has done, we have the right to test and get answers as to why he did it. And the same with Dr. Scorty Bello. Once he goes to this level, Your Honor, I believe it's a straightforward right, especially of a defendant in a criminal trial, and especially of the stakes and the charges this high, that we get to test it. What I think, lastly, my point here, Your Honor, the Commonwealth is doing is this. The Commonwealth knows Trooper Paul and Dr. Scorty Bello are problematic for their theory and their narrative. Trooper Paul has got, if you work backwards from his key cycles, you end up with 1162-2, their key cycle. That ends up being not in front of 34 Fairview, but it ends up when the Lexus is in the possession of the state. That is the result of that. And that was something that was addressed square head on in the first proceeding. We're not coming up with some fanciful ghost in the second trial. This was gone through extensively in the first proceeding. And I understand this is a new trial, but it goes to show it's not something coming out of the blue, etc. And with regard to Dr. Scorty Bello, it was remarkable on the redirect that I've never seen a prosecution essentially go after the opinions and conclusion of their own medical examiner when they basically said, the medical examiner, I can't call this a homicide. The manner of death is undetermined. And the medical examiner says, I don't see any motor vehicle impact injuries. There couldn't be anything more apt, more probative than whether or not the injuries to the decedent are from a motor vehicle. The Dr. Welcher himself is saying they are. That's the essence of his opinion. It's the essence of his test. We get to be able to respectfully, Your Honor, say, well, wait a minute. You said you looked at the autopsy. You said this. You highlight it, but you're going against the medical examiner on whether there's motor vehicle injuries. The experts can't, Your Honor, cherry pick and choose from documents. They can't use it as a shield and a sword. They can't put up, for example, Dr. Scorty Bello's autopsy report, cherry pick things to benefit from them, and then and they did it on direct. And then all of a sudden on cross, when we want to go and test that, they say, oh, no, you can't do it. Your Honor, this whole argument is absurd, and it's antithetical to the Sixth Amendment. And even if, and this is my last point, even if this were merely a civil case, this would be routine cross-examination against the expert on the side. So in conclusion, Your Honor, I respectfully request that Ms. Reed and her team be allowed to exercise their constitutional right to cross-examination, the keystone of a defense in a criminal trial, cross-examination, and that they be able to take the shield that the prosecution is trying to put on us and be able to combat the sword that the prosecution has put forward with regard to trying to cherry pick from this information, and that we get to proceed, and we get to proceed undaunted from all the serial objections yesterday that interrupted my cross-examination. Thank you, Your Honor.
What arises from the litany of complaints by the defense is that there is no constitutional right to usurp the rules of evidence. There is no case law, as much as they urge the court and yell out the word case law and constitutional right and Sixth Amendment right. There is no case law to support what they are trying to do. It is a simple endeavor that is clouded by all the rhetoric that they offer. And it is clear, and the court knows what they're trying to do. They are trying to pit the inadmissible opinion of a non-testifying witness against a testifying witness. They have asked Dr. Scorty Bello what her opinion is. And although it's not consistent with our reading of the case law, they were allowed to introduce that it was an undetermined cause of death or mechanism. That evidence is already in front of the jury, but they can't simply repeat it because it sounds good to them or they think it's helpful. Simply because a witness uses a document or looks at it or uses part of an autopsy does not let them regurgitate an opinion that's already in evidence to try to phantom cross-examine an expert. Dr. Welcher is clear. He did not rely on Dr. Scorty Bello's conclusion that this cause of death was undetermined. In fact, as an aside, he said, I wouldn't, because she's not qualified for that. And so this is a simple game. Let's pit one witness against the other and suggest that the Commonwealth's witnesses are inconsistent. They take it a step further. They want to relive what they think is their past success last year in this case without actually calling the witness. They want the jury to hear their perspective that a past witness had confusion in his analysis, but they don't want to call the witness. They want you to allow them to do that, not just shouting it out and have sustained objections, which has happened this entire case, but they actually want you to be able to allow them to ask Dr. Welch these questions, which he did not rely on. We had a voir dire. He was clear. He did not rely on the analysis of Trooper Paul. He did not rely on that determination or undetermined determination by Dr. Scorty Bello. It is that simple. They try to throw some fluff out and they throw around some documents. We have slide 22. Simply because there's a suggestion that Trooper Paul might be the hand in the picture is not an anchor. It's not a tether. It's not an adoption. It's no such thing. In fact, if you look at that photograph, it was taken by Zach Clark. So by the rationale of the defense, they should now be able to ask Dr. Welcher any question they want about Zach Clark's opinions, efforts, what Zach Clark did. It is a photograph that he considered, not an opinion, not an analysis. It has nothing whatsoever to do with Dr. Welcher's analysis or opinions. In fact, the evidence is to the contrary. He came out, conducted an independent analysis, did all of the work himself, considered documents, and he was specific about what was part of his opinion and what was not. And this information was not part of his opinion. They turned to the Google map. Bit misleading. This was generated by Google. Two separate people used the same program, but when you look at the CARS report and you look at Dr. Welcher's PowerPoint, it's different. Dr. Welcher's has a map on the side, and when you look at the numbers themselves, the CAR report says minimum 36.1, maximum 38.8. Dr. Welcher's slide, 37.9, 38.1. So in no way did he adopt, anchor, tether, use as any basis. In fact, his is different and separate, as all of his analysis is. And so the portrayal of this necessity of information so they can sneak in inadmissible opinions with no witness is simply improper. There is no case law. There is no legal support for it. They cannot reach back into last year and manipulate a witness and ask him about something that he didn't rely on because it feels good or it sounds good for their case. Dr. Welcher did not rely on Trooper Paul's analysis or reports, and he did not rely on the conclusion of Dr. Scortibello of undetermined. If they want to call Trooper Paul, well, maybe they can try to do that, but Dr. Welcher is not the right witness for it. These opinions to try to do a credibility value is a core preclusion in criminal law, a core preclusion. You cannot vouch for the credibility of another witness. You cannot comment. It's like asking, did the police officer lie when he said the light was red? It's the absolute same analysis. It just has a lot of icing on it.
Very briefly, bring the jury, start getting the jury ready, please.
Your Honor, with regard to Trooper Paul, Mr. Brennan did not address 80% of the slides that I addressed that showed the basis. When he talked about the picture, making it seem like the picture is the only thing we're relying upon, there's clearly other items, but even the picture, Your Honor, the purpose of the picture is it's got the odometer reading. That's why they took the picture, and that's the tether. So the photo is completely relevant. It's not who's in it. It's the fact that that's the odometer reading they're using. Next point with regard to case law, Mr. Brennan presents none to go against the common sense law that has been there for years. The other thing, Your Honor, is with regard to Mr. Brennan keeps trying to put my arguments into a credibility, like we're trying to attack the credibility of Trooper Paul. He says that we're trying to redo last trial. To the contrary, Your Honor, it's the Commonwealth that brought Trooper Paul into the second trial through Dr. Welcher and Dr. Welcher's reliance on all the work of Trooper Paul. They've brought it in here, and because of that, we get the right to cross-examine it. Last point. This is not about credibility. He keeps saying something that's not happening, that we're going to attack the credibility of Trooper Paul. What we want to do is to say to Dr. Welcher, you have brought up Trooper Paul. You have used his odometer reading. That odometer reading tethers through to Google. It tethers through everything you're doing. It's the foundation. But what you're ignoring, Dr. Welcher, are all the key cycle results that come from that odometer reading that you relied upon. Dr. Welcher himself can't cherry pick, grab things that he needs from Trooper Paul to do his analysis, and then the Commonwealth say, but you can't go after that because it somehow has Trooper Paul's name on it. It's illogical, Your Honor, and it's incorrect under the law. Thank you.
So I disagree with you, Mr. Alessi. I'm not allowing in the line of questioning regarding Trooper Paul, and I'm not allowing the line of questioning regarding Dr. Scortibello. So that's my ruling. Let's bring the jury in. Well, come over here because they're on their way.
After Yelesi's petulant little act there, still nothing.
Yeah.
Just nothing. Denied.
I'm actually feeling assaulted. I feel worn out. Like he
Oh God, yeah.
just yells and yells in circles. There was no way that's going to be approved. In a nutshell,
Right.
you can't have another witness say what another witness said, and it's
Right.
another trial. It's like that trial never happened in terms of this trial. You can't conflate the two.
They could call on Trooper Paul if they wanted to. They want to use Trooper Paul without calling on him. That's right.
Exactly.
You know.
No, I agree. That's Yalessi. He kicks into his scary Mason mode, and when he's got nothing left in the tank, that's when the volume goes up, right? But at least he spared us the crunching paper this time, thank God. But yeah, that's a sure sign when they're flailing is either Jackson in theatrics or it's scary Mason appears. It just starts yelling at everybody. It's a waste of time.
Yeah, that yelling thing that he does is obviously a deliberate decision, whether he decided on his own or Karen told him, you need to make a point, you need to be louder, and he just goes up to that screaming thing, and I have to pull my headphones. I'm like, whoa, what is that? Is painful.
That's right. For us brothers of the headphones. That's right, man. It's horrible. It's terrible. Yeah.
I have earbuds. I don't trust them.
No, I got the over the ears, man. It's the way to go. But,
I mean, I have some regular earbuds, but it's like they're so sensitive. You touch it and you accidentally turn it off, or you change the volume. Like, screw this. I'm just going with the headphones.
And you really want Alessi that deep in your head, man?
No.
He is so become the face of this trial for Karen Reed.
Yeah. Who expected that, right?
Yeah.
Everybody says, well, he's good with experts. Well, he's a civil. He's good. No, that's ridiculous. AJ should be able to cross-examine anyone, and we've seen him cross-examine experts in the past and did a great job. I think this
a lot of it feels like, doesn't it feel like a lot of it like law school, a law seminar, semantics, like people debating this fight instead of what actually is to get to the truth or what actually works for the jury or something like that. It's just he's always trying to needle down to this Socratic point and then get some kind the witness to say something that he can later misuse against him. I don't know.
Yeah.
Where they use it is in closing. They say, see, he said this. Oh, see, he said, take one little nugget off of, 3 days worth of testimony. And they say, see, you'll remember when he said that.
And he'll also use it even on the stand yesterday. Like he'll get Welcher to say something and then he'll distort it and he'll say, well, didn't you just say, but Welcher's too smart to fall for that.
Yeah.
I love how Welcher says, no, I didn't.
Good morning, judges. I do appreciate you were waiting. We were doing work in here, but we appreciate your patience. So I do have to ask you those 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. Everyone said no or should. Thank you. Could we have Dr. Welcher back in, please? And Mr. Leslie, feel free to go to the podium.
With the computer and any electronics there, so we don't have to address it.
It doesn't look like it's turned on at
Oh,
all.
okay, good. And smart watches.
So this one.
Sir, I'll remind you, you're still on your own.
Thank you. Good morning, Your Honor.
And Dr. Welch, we're going to ask you to not turn on your computer yet.
Okie dokie.
Thank you.
And Your Honor, if I could, smartwatches that are receiving text messages during his direct, if we can make sure that that does not occur.
I can get my email on the line. I'll take all the time.
Okay, or just don't look at your watch.
I'll split it, okay?
Okay.
Thank you, Your Honor. Morning, Dr. Welcher.
Good morning.
Do you know whether there was glass found on the bumper of Miss Reed's Lexus SUV?
It's my understanding there was, yes.
Did you reach a conclusion on whether the glass on the bumper came from the drinking glass that you assert Mr. O'Keefe was holding at the time of the alleged impact?
I didn't have an opportunity to inspect the glass, but the glass was broken and there was glass on the bumper. That's all I know.
So you, as you sit here today, you have no basis to conclude that the glass on the bumper came from the glass that you depict as having been held by Mr. O'Keefe at the time of the alleged impact. Is that correct?
Well, you're mixing a couple things.
No, Dr. Welcher,
So
if you can just answer my question.
I'm
If
trying
I
to.
need to rephrase it, I will. I'll ask it a different way.
Please.
You have no basis as you sit here today to conclude that the glass on the bumper came from a drinking glass connected to Mr. O'Keefe, do you?
Well, we have a picture of a broken glass at the scene. So I wouldn't say we have no basis. We don't necessarily have enough to conclude it's from it, though.
Do you had depictions in your test with Mr. O'Keefe holding a glass, correct?
Correct.
My question is, you have no evidence to show at all other than, and I'm talking evidence, testing information. You're saying you have no evidence that shows that the glass on the bumper is not the same glass as you showed on your slides as being found supposedly at the scene. You have no test evidence that that's the same glass, do you?
So again, the one I have at my testing obviously was not the same glass. We have pictures of a broken bar glass in the snow near where Mr. O'Keefe's body was. We have glass fragments on the rear of the bumper. That's the extent of my knowledge on the correlation between those two.
So do you said you reviewed the reports and testimonies of various Commonwealth representatives, correct? That's in your report.
Correct. In the initial.
Right, correct. And some of those reports included forensic scientists who work for the Massachusetts State Police, correct?
I believe that's correct.
And you put those in your report as documents that you reviewed, correct?
Correct.
And as you sit here today, it's your testimony. You don't know whether in any of the reports of the Massachusetts State Police, there is an answer to the question of whether there's any connection at all between the glass found in the snow and the glass on the bumper.
I recall it being inconclusive.
Oh, so you recall that the testing was inconclusive?
I don't remember what testing they did, but for example, when they put the taillight fragments back together, they were able to deduce that the fragments were from the taillight. I don't think they attempted to do that with the glass.
Assume that there has been testing of the glass on the bumper, and assume that that testing conclusively determines that the glass on the bumper is not the glass that was found in the snow.
Okay.
Assume that.
Okay.
How would that affect your analysis?
I'd want to know where the glass came from, but we still have a whole bunch of other elements. So I don't think it would affect the end results.
So would it have any part in your analysis with my assumption that the glass on the bumper is not the glass that's associated with the broken glass that was supposedly found in the snow?
Yes, I mean, we always want to have as much answers or as many answers as possible. So I would want to know if we could figure out where it came from.
And wouldn't the fact, assuming that the test results show there's no connection, meaning the glass on the bumper is different from the glass in the snow, wouldn't that be contrary to your theory of what happened in some way?
It depends on when the glass was actually broken. The glass was in his hand, at least that's the testimonial evidence I have seen. So It depends on whether it's broken from contact with the rear of the vehicle or broken with contact on the ground.
Assume that the glass on the bumper is not the glass that was found in the snowbank. Doesn't that, at least in part, contradict your hypothesis as to whether there was contact by the Lexus with Mr. O'Keefe at 34 Fairview?
So if you recall on my slides, nowhere did we discuss that in my slides. So no, it wouldn't contradict it. I would want to know where that glass came from.
But you didn't seek that information, did you, sir, in your analysis to determine where the glass came from?
Well, of course I did. I read the reports about it.
But you sit here and you say you don't know the answer. There's steps you could have taken to get that answer quite easily. Couldn't you have, sir?
Not me. That's a material science expert.
You've been communicating with Lieutenant Tully, haven't you?
Correct.
You couldn't have asked Lieutenant Tully that question?
To my knowledge, he's not a material science expert.
But could he have told you the result of testing on that glass on the bumper and whether it was any way associated with the glass found in the snow? Wouldn't that have been an easy question to ask him? Just, has there been testing, and if so, what's the results?
Yes, but my knowledge from reading the reports was it was inconclusive.
But you didn't read all of the reports, did you, sir?
Apparently not.
Let's turn to another topic, laser scans. Part of your analysis involved conducting laser scans of portions of 1 Meadows Avenue, the house of Mr. O'Keefe, correct?
Correct.
Those laser scans were used, at least in part, to answer the question of whether the collision between Miss Reed's SUV and Mr. O'Keefe's Chevy Traverse at 1 Meadows at approximately 5:07 a.m. on January 29, 2022, caused the right rear taillight of the Lexus to break, correct?
Correct.
And in that analysis, inches literally matter, correct?
You want to get it as accurate as possible.
And the reason why inches matter is because, and we're going to get to this, you try, and you did it in your slide presentation on direct, you tried to see whether the Lexus lined up with the Traverse such that there could be a break of the taillight. That was part of your analysis, correct?
So the main part of the photogrammetry was to determine the speeds and the angles and the degree of overlap on the vehicles. And then we also looked at the damage from the video, or actually it's just where the snow was knocked off the rear of the Chevy Traverse, and document the height of that.
You said the main part. I don't want to engage in semantics. I want to go to my question of, isn't part of the laser scan analysis to determine whether or not those two vehicles align sufficiently such that the Lexus could break, the taillight of the Lexus could break coming into contact with the Chevy Traverse? Wasn't that part of your analysis, at least in part?
Yes.
Okay. And in that analysis, inches literally matter, correct?
It can, depending on which way you're going inches.
So the ring camera at 1 Meadows, you're familiar with that ring camera, right? At
Correct.
1 Meadows? That ring camera at 1 Meadows was used as part of the laser scan process that you and your firm Aperture performed at 1 Meadows on October 2nd, 2024. Do I have the date correct?
I believe so, but like the videos were not literally used during the laser scans. We took the laser scans, the video, combined them together in a process called photogrammetry.
Okay, let's get this down to the fundamentals. You used, and that was my question, Your Honor, if we could publish the exhibit with regard to the ring camera.
Sure. What exhibit is it?
Yeah, I've got my, here you go. Dr. Welcher, you recognize that ring camera being at One Meadows. You discussed it, as a matter of fact, on your direct testimony, correct?
Yes.
Now, that ring camera was utilized as part of your laser scan process, correct? It was used.
So you're confusing laser scan and photogrammetry. The video, the laser scanners are together used in the photogrammetry. The camera and the laser scans are not used necessarily with each other.
Was that ring camera used for any part of your work?
Absolutely, the photogrammetry.
I just need to be able to finish my question, sir. Was that ring camera used for any part of your work at One Meadows on October 2nd, 2024?
Yes.
And it was used for what purpose?
In the photogrammetric process, to establish the position and dimensions of various things in the video. So then we could go back and overlay the vehicles and track the tracks in the snow, as well as look at the damage to the vehicles.
Right. So this was used as a basis, not the only one, to establish dimensions of the other work that was done in analysis at One Meadows, correct?
Correct.
You can take that down, Mr. Wolk. You know that the ring camera at One Meadows, in existence when Aperture did the work on October 2nd, 2024, was different than the ring camera that was in existence on January 29th of 2022, the date where you went through to see if those two vehicles align. Is that correct? The cameras are different.
That is correct.
And you know that the cameras are different, and you knew that as part of your analysis, correct?
Correct.
Did you document the differences between the two cameras as part of any work performed at One Meadows?
Yes.
And did you measure any differences there might have been between the location of the newer ring camera from the older one that was in existence on January 29th of 2022?
No. What you did is use the current ring camera in conjunction, and with the laser scans, we're able to, again, map the points onto the scene. That's why I showed you the report from the photogrammetry software that reported our error.
Sir, my question was just measurement, not your process.
Oh.
Did you measure the difference
I don't believe so.
between where the old camera was and where the new camera was?
No, it was angled slightly more to the right, though.
How would you know that if you were not retained on January 29th of 2022? How would you know where the original angles were?
Because when you look at the first camera, the one on January 22nd, it's here. The new one is slightly over to the right.
That's an eyeball approximation analysis. That's not a measurement, correct?
Well, I don't know that we actually measured it, but we accounted for it and corrected for it. But you can see, for example, what the original one shows, for example, to the left-hand side, compared to what the new one shows to the left-hand side, and it's angled more to the right.
Sir, you have experience with ring cameras, correct?
I do.
And I think a lot of members of the public have experience with ring cameras. You can move just the camera portion ever so slightly and change significantly the angle of the camera, can't you, what it captures? Just a small turn.
Potentially.
Right. Even a millimeter turn can make a change. A 2 millimeter, a 1 inch can make a significant change with regard to what the camera captures, correct?
Could, sure.
So, did you measure whether the newer camera that was present on October 2nd, 2024 was installed to the left, and I'm talking measure, to the right, to the top, or the bottom relative to the camera that was there on January 29th of 2022?
So we solved for the camera position.
I'm asking if you measured, sir.
Oh, no, we didn't measure.
So let's talk about some other differences with regard to cameras and Ring cameras. Different Ring cameras can have different levels of distortion, correct?
Potentially.
Cameras, well, are you saying that all Ring cameras have the same level of distortion?
No, but again, they're mass produced, so you could have some that have the same exact distortion. You could have some that have different.
And you don't know the comparative distortion between what I'm just going to now refer to as the old Ring camera that was there January 29, 2022, and the camera that you saw on October 2024, which I'll refer to the new camera. You don't know the difference in the distortion between those cameras as you sit here today, do you?
So we know enough information that if the distortions had been different, our errors would have been too high. And so the fact that our errors are within acceptable, are what's called an RMS error, we know that the distortions are similar enough to give us accurate measurements.
Sir, that is speculation. That is not data. That is not a measurement. You didn't measure the distortion, sir, did you? If the cameras, you didn't have the old camera to do it.
We didn't, but we had images from the old camera. And then when we get images from the new camera and solve those camera properties and then overlay data from the old images to the new images with the point clouds, if that distortion is too great, we will have too high of errors in our project, which is why I showed the error report from the photogrammetry process to show that we have checked for that and documented that our errors are an acceptable range so that we have confidence in our results.
You do not have information from the manufacturer of Ring. You didn't present it and you don't have it as to what is the acceptable level of distortion for the analysis that you did, do you, sir?
The
Do you have that from Ring?
I don't have it from Ring, but I don't need it from Ring.
So now let's go to, if cameras have different levels of distortion, that would change the analysis in reconciling the difference between their angles. That's a pretty straightforward proposition, sir, wouldn't it?
So it depends on how much difference it is, but we
was present at One Meadows on January 29, 2022. Which model?
I don't know. I'd have to go look through the data.
Do you believe you, I'm not going to take up the time to have you look, but do you really believe you've got the model of the Ring camera that was in existence on January 29th of 2022?
I don't know. I
You
need to
didn't
look
present
through
it in your direct testimony, did you, sir?
I did not.
So do you have the model of the Ring camera that was present at One Meadows on October 2nd, 2024?
No.
So you don't have even the model for either one of them?
Nope, but we have videos from both of them and scans of the scene.
So now let's talk about another aspect of Ring cameras. They have mechanisms, as I was talking about earlier, that allow the user to adjust the camera angle, correct?
Correct.
And do you know whether there was a difference in the camera angle between the two cameras?
Yes, as we already discussed, there was a slight difference in the
But
angles.
you don't have a measurement of that, right, sir?
Correct.
Okay.
But we accounted for it.
So wouldn't a difference in models of Ring cameras be relevant at all to your analysis of trying to reconcile any differences between them?
So if you have video from both of them and you have laser scans with three-dimensional geometry of the scene, you can go in and it's called a reverse camera analysis and solve for the distortion properties. The scans give you the real world dimensions. So once you know the real world dimensions, you can then go in, you can go in and then solve for the camera lens properties based upon the real world distortions. So for example, if there's a little bit of bending at the end, the laser scan data will show that, and you can correct for that, knowing information about the laser scanner.
I'll
or
ask
the
the
laser
question.
scan data.
I'm sorry, I thought you finished, sir. I'm going to ask the question again because it's a narrow question. Wouldn't knowing the difference in the models be relevant? That's all I'm asking. Wouldn't it be relevant to your analysis of reconciling the differences to them? Wouldn't
No.
it be relevant?
No.
So you think the different models are irrelevant to any process you occasioned at one? It's irrelevant.
So the analysis of the video itself is more important than the models?
I'm not asking if it's more important. I'm just asking, would it be relevant?
No, I don't believe it'd be relevant.
Now let's go to another aspect of the cameras. Are key parameters in a camera that the software needs to know focal length?
It is.
Is imaging size something that is an important parameter in a camera?
Yes.
Are sampling characteristics an important parameter in cameras?
Can be.
Is the principal point, you understand that concept, sir? Is that an important parameter in a camera?
Define how you're using principal point.
Sure. A principal point of an image is the point where a camera's direct line of sight, called, as you may know, the optical axis, enters the image plane. Does that
Gotcha,
sound
yes.
familiar?
Mhm.
So isn't that the image's mathematical center, the principal point?
More or less, yes.
And for high accuracy photogrammetric work, it's important to know if the lens is mounted centered over the image sensor due to the small manufacturing variances, correct?
Could be important.
And if the principal point is the center of the image. That's relevant. So doesn't that affect the mathematical calculation of the light ray geometry?
It could.
So the variance in manufacturing between cameras is a known issue. Do you agree?
I do.
There's small manufacturing variances that affect one of the key components of the fundamental parameters of the camera, namely the principal point, right?
Correct.
Did you perform the camera calibration of the camera in place in October of 2024?
Yes. So within photogrammetry, we calibrated the photogrammetric analysis to the camera.
Did you address the principal point in that calibration? Do you have documentation that you addressed that important factor, the principal point?
So the checking of the RMS error in the software takes into account, sums up all the potential errors in the measurement, which would include that.
Okay. Sir, you know the importance of all of these topics because the output of all the work Aperture did at One Meadows, almost all of it springs from that camera, correct?
It starts there.
Okay, it starts there. And if the starting point is wrong, then where you go from the starting point is going to be at least potentially wrong, correct?
Potentially.
Would you agree that Ring cameras have a swiveling mechanism so that the user can adjust the camera angle? 2022 had a swiveling mechanism?
I believe it did.
Believe? Do you know?
I do not know for a fact, but
you-
those style of Ring cameras on the surveillance have adjustability that includes angle.
But you don't know whether the camera that was there, the specific camera on January 29, 2022, had a swiveling mechanism or not, correct?
Correct.
Had a swiveling mechanism on it.
It did.
And where did you document the fact that it had a swiveling mechanism?
I think we have photos of the camera.
Did you document it in writing, and did you document the tolerance of the swiveling mechanism?
No.
Let's go to, and again, all of the camera, this camera that you use is the starting point for your laser scan and photogrammetry process, correct?
Correct.
All right. Let's go to another topic. On your direct testimony, as I recall, you stated essentially from various information that you lined up in the video, and we're talking about the lining up of the Lexus with the Traverse. And this is at One Meadows. And so, as I understand what you did, sir, is you took what are called point clouds, 3D images, created them for the Lexus. You took created 3D images, synonym point clouds of the Traverse, and then you attempted to line them up to determine, among other things, whether they would align sufficient so that the Lexus could line up and potentially hit the Traverse such that the tail light of the Lexus could be broken. Was that at least part of your analysis?
That was part. There was more.
So you showed a slide, a few slides, and with your Honor's permission, what I'd like to do is to start with slide 90.
All right, do you have any problem with Dr. Welcher keeping his printed copy that he was using?
I have no problem with the printed copy, Your Honor.
So, I'm sorry, what slide again?
90.
Your Honor, I printed out tiny.
Okay.
Can I
Can
pull it
you
up?
see the?
Yes. Yeah.
Does that slide that's part of your presentation depict a view from the top of the Lexus on the right and the Chevy Traverse on the left?
Correct.
And is that depicting contact between the two vehicles?
It is.
Now let's zero in a closer look, and that is a contact point. Am I correct?
Correct. I mean, there's multiple points. There's more than
Multiple
one.
points, but it shows more clearly the contact
Correct.
between the two vehicles. Now, if we could the next, and that is number 91, Mr. Wolf. So Your Honor, 91. I think these are just going to go in order for a few, and I'll keep announcing them. So this is 91, same vehicles, just a different viewpoint. Is that correct, Dr. Welcher?
Correct. This and the next slide.
I just want to stay
I know.
with this one. I
Hold
just
on a
asked the
second.
question, does it show the contact?
So go ahead and answer now.
This slide and all the other slides, we're trying to show the angle of contact, but because it's two-dimensional image, you're losing some perspective. For example, here you're seeing the chrome piece on Mr. O'Keefe's Chevrolet, which is on the right. You're seeing it obviously behind where the Lexus is. So we were trying to show it at a whole bunch of different angles to try and illustrate the degree of closeness or lack thereof.
Alrighty. So
Thank you.
is it correct that on your direct examination, you said in sum and substance, we looked at the degree of overlap, and there's only about a 2 to 3 millimeters of overlap between the vehicles. Is that what you recall saying on direct?
That is correct.
And that you stated that supposed 2 to 3 millimeters of overlap was insufficient to cause the tail light of the Lexus to contact the rear of the Chevrolet. Do you recall saying that?
That's correct.
Now, I would like you to look at that. This is from your slide presentation. Is that not showing contact between the two vehicles?
Oh, it absolutely is not. What you're seeing is a portion of the vehicle that is behind the area. Keep in mind the angle, the Lexus is angled off to the left. So the area that you see here is actually, in this case, in front of where the taillight is. This is why we tried showing it from a whole bunch of different angles, because when you try and take a two-dimensional image and look at it, you see stuff in the background. So and again, this is why in the computer, we overlaid them, looked at the measurements, in the computer where you don't have this, we have the three-dimensional measurements, and it does not hit.
Where did you show in your slide presentation what you just said, that it doesn't show in overlap?
So
Where?
it shows a contact. It definitely contacted, I'm sorry, Mr. Reporter, down below here. It does not show a contact here. So to answer your question, all the next slides were our attempt to do that. So all the next slides is your answer.
We're going to go to those next slides. So you're, just to be clear, you're saying that that depiction does not show any contact between the taillight of the Lexus and the Chevy Traverse.
So the upper taillight, just to be clear, because the lower taillight is much closer.
Well, it's not only much closer, it's in contact, isn't it, sir?
It's very close. It's probably within an inch of being in contact.
Oh, so you state that even the lower part of the taillight is not making contact?
So if, again, maybe there's a photo we could show or a scan that is on the rear of the vehicle and it contacts on the corner, which is just around. So maybe like an inch or so in front of it on the corner.
I'm just going with what you presented in your slide
Well, let's go to the next
presentation.
slides and then
Sir,
maybe
I
we'll see
will
it.
determine which slides we go
Okay.
to on my questioning.
I'm just hoping
So
to
now
answer your
let's
question.
go to, Mr. Wolf, the next slide
There we go.
in your presentation. My question is zeroing in. Are you saying that that slide does not show contact between the tail light of Ms. Reed's Lexus and any part of the Chevy Traverse?
Yeah, absolutely. It's exactly what it shows. You can see a little better here. Again, we tried all these different angles, which is why all these slides are in there. But you can see some of the geometry of the light. This structure, and again, remember I said the Chevy kind of curves in as it goes up a little bit.
Let's go to the next slide. 40, yes, please. Is it working? 41, Your Honor.
That's exhibit 41? No, I have a question because it's not my slides.
So, Mr. Alessi, is this exhibit number 41 or is this from the PowerPoint? Because,
Slide 41. Slide.
okay.
Yes.
So I'm putting this up because I want to show an actual photograph of that tail light. And I would like you, sir, to focus on the quarter panel tail light in each. Do you see a jutting out of the quarter panel tail light in that photo? You see it jut out?
So I don't know if you and I are talking the same thing. There are little fins here.
Correct. Now, what I'd like to do is to go back to the depiction we were just looking at, and that depiction doesn't show the jutting out, does it?
No, it does. Those are actually more on the side of the vehicle. You can't see them in this image.
Correct. You
But-
can't see them.
Hold on a second. I wasn't finished. But
Sir.
they are 100% there. We actually did special hand scans with a hand scanner of the taillight to put it back on to the vehicle.
You say they're 100% there, but you can't see it in that depiction, can you? The jutting out that you could see in the two-dimensional one we just saw. You can't see it.
I can't see who's behind that wall because it's being blocked by something. I can't see on the side of the tail light because it's on the side I can't see. It's being blocked.
Sir, my question is simple. You cannot see the jutting out of the tail light in this depiction, can you?
Correct.
Okay, now let's go on to the next question in this topic. You could have easily solved what you consider to be the issues you had with trying to show it lining up, couldn't you, sir? You had an easy solution for that.
I took the best solution. I'm not sure what
You
you're
had
referring to.
3D images, correct?
I did.
You could have shown and measured 3D images to get almost the exact contact point and almost the exact dimensions if you had just used the 3D images that you had available to you. Isn't that correct?
That's exactly what we did. When I went through the video analysis, I showed you how we overlaid the point clouds, the 3D scans on top of each vehicle. So we took the, I'm sorry, we took
Sir,
the vehicles.
please don't interrupt.
Hold on.
Your
Hold
Honor,
on.
he keeps referencing my hand and saying I'm doing something when I'm not. And I think that's distracting to the jury.
So-
I'm not interrupting
Hold
him.
on. Let the witness answer the
I
question.
am. I'm just holding my hand like this, Your Honor. He keeps saying that I'm doing
Mr.
something.
Leslie, please.
All right.
Go ahead, finish the answer, Dr. Welch.
Again, in the photogrammetric analysis, I showed the video. I showed how we overlaid the point cloud on top of the video. That proves that the way we solved it, correct camera characteristics, matches. Otherwise, that would be distorted. We overlaid the scans of the Lexus into the photogrammetric analysis. We overlaid the scans of the stuff into the analysis. We did exactly what you're suggesting.
You could have easily addressed this issue by the following. If you really believe there was no contact or not sufficient contact, you could have produced a graphic that shows a gap between the two vehicles. A graphic, couldn't you? That's not a graphic.
What is that?
Sir, I get to ask the questions and you are to answer them subject to the judge's ruling. So my question is, couldn't you have created a graphic that would have better shown the issue that you are creating or talking about today? That's my question. Couldn't you have created a graphic?
We did. We created a whole bunch of graphics.
You called what we just saw a graphic?
Yes.
Well, if there's a gap, why isn't there then something that shows a clear gap?
Because when you have the angulation of the vehicles, you have perspective. When you're looking at it, even if you do a top down, you see everything projected onto a single flat plane. So you can't tell the height of things. So when you see things in this dimension, you can't necessarily see depth of things. So you lose in two-dimensional images, you lose one dimension depending on which way you're looking. That's why I showed it from all these different angles to try exactly what you're saying. We had graphics to do that.
3D images allow you to show perspectives for 360 degrees, correct? Is that correct?
That is correct.
So none of what you presented in your slideshow shows the contact points from 360 degrees, does it?
I don't understand your question. Are you asking if I showed it at every single, I went through 360 slides that showed it at every single degree?
Sir, let's move on. I think I've made the point.
So I'm going to strike the comment,
Okay.
Mr. Leslie.
Dr. Welcher, let's go to the next topic. And keep with these two depictions. Are these two images point clouds or 3D images? Are these
Those
two-
are one and the same thing. Yes.
I would use them as synonym. Which term of the two do you want to use? Point cloud or 3D images?
Both are fine. It's a 3D image composed of points, which
Okay,
I'll,
so let's just call them 3D images, so we
Okay.
can do this more quickly. The Lexus and the Chevy Traverse that are depicted there are both 3D images of those vehicles, correct?
correct.
And Aperture created the 3D images, correct?
Correct.
Sir, did you do these scans and did you personally create these images?
No, one of the assistants at Aperture did.
So you're speaking about what somebody else did at Aperture, correct?
They were doing it at my direction. And for example, the Lexus scan, I showed the photographs. You can see the gentleman that works at Aperture, Mike Morelli, was scanning them for me while I was doing the rest of the inspection. And then the hand scanning of the rear tail light was done by another engineer. I was out there with him doing it, taking measurements. And then same thing with the Chevy Traverse.
My question is, you didn't do the creation of these 3D images, did you?
The individual images, no.
All right, so let's go to these individual images. These are 3D images. Is that your testimony?
Yes.
Let's look at the tail light.
Okay.
That's not a 3D image. That's a Photoshop, isn't it?
Nope.
Oh, so it's your testimony that that tail light is a 3D image.
That absolutely is a 3D image. The way you can tell is when you get up near the chrome, because lasers don't like shiny objects, you start to get a scatter. So see all these dots here? If that was a photo, you wouldn't have these dots.
Let's go to the Chevy Traverse. Let's, Mr. Woke, zero in on the content. Yeah. There's grain on that tail light, in the tail light. That's a 3D image of a tail light, isn't it, sir?
They're both 3D images.
Well, I just want to stay with one. That tail light is a 3D image, and one of the ways you can tell is it's got all that grainy material on it, correct?
Correct.
Now let's go back, Mr. Woke, to the Lexus. Let's now go to the bumper.
But do you want me to explain the difference?
No.
Okay.
Thank you. I would like to go to the bumper. Do you see any the predominance of any grainy image on the bumper?
There's a little bit. So for example, when you get near edges, it has a hard time with edges.
I'm sorry, the bumper cover.
Right.
See the bumper cover up above?
This whole thing is the bumper cover. That's the step pad. That's the rear body panel or the rear deck lid.
I'm talking about the step pad, sir. Just the step pad of the bumper?
Are you asking about just from here to here?
Correct. The bumper step
Can we
pad.
zoom in on it?
Pardon me?
Can we zoom in on it?
Sure. Do you see any?
Yeah, I see graininess.
Let's go over to...
Right in here. You can see it all through here. You see it through here.
Well, I'm talking about the step pad, not the entire bumper. I'm just talking about the step pad.
Right. So you're zooming in on the bumper.
Right.
The step pad is this structure up here.
We're going to move up. It just takes a while. So your testimony is that is a...
Can you zoom in more?
That's, you would like it zoomed in?
Yes, sir.
Sure. Your testimony is that is a 3D image, not a Photoshopped step bumper cover. Is that correct?
So we have mapped the color over the 3D scans. We used two separate scanners. If you recall, when I got out to Miss Reed's vehicle, that taillight was gone. So we had to replace the taillight.
Talking about the bumper cover, not the tail light.
Okay, I'm explaining the process.
I'm just asking about the bumper cover, not the process.
So focus your answer on the bumper.
That is a laser scan.
Okay, so your
That's a 3D
testimony
model.
is the step part of the bumper cover is a 3D image from a laser scan, and it's not a Photoshop. That's your testimony.
Absolutely.
And you didn't perform the work for the 3D that you claim the bumper step up is. You didn't do that work to produce that depiction, did you, sir? Somebody else in your firm did it.
So this is all done at my direction. The engineers that work for me, so I'm telling them what to do. I'm not the one punching the keys.
That's
I'm
my
saying,
question.
I need you to do this, 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 and this. Use the hand scanner, go scan the light. I need to put this back in because it was missing when we got to it. So no, I'm not punching the keys.
Okay, so
Okay. Come on over, please.
This is ridiculous, man. This has turned into a sitcom. What is happening?
Actually, I'm actually entertained now.
Oh man, I've been laughing out loud too.
My husband walking back and forth like, who is that tool that's talking?
Yeah, no doubt.
Confused it when he threw that little fit. You're
Oh.
he's looking at my hand.
Yeah.
He's making fun of me.
I just made my point. What point? That you're nuts, that you need to change your medication? I don't know what you're making. Oh my God.
Of course, the key thing is, I wonder what the impact of this on a jury, because we can't tell. But my impression is, if you're a jury sitting there, first you're a little angry, but second of all, you're like, is this all you got, man? To me, I'm like, if you're splitting hairs like this with all this sophistry to try to force him to say something continuously, and that's all we see, and unless he's been pretty much their main cross-examiner, my impression is, people can say this is biased, but that a normal juror sitting there is going to say the defense has no defense. They have nothing.
Well,
No kidding.
When his main point for 10 minutes at least was you didn't make enough charts, and trying to say his chart wasn't a chart. That was hilarious.
Right.
He said,
Right.
"You're calling this a chart?" Yeah, it's chart, and we're all looking at a chart.
My God. Are you saying that's not a Photoshop? Exactly what I'm saying.
Oh,
but it could be. What?
And he gave Welker more chances to just explain how there was no contact between the vehicle, between the upper tail light and the vehicle, and explain it very effectively. It's like he's given him more chances, so that's going to be even more remembered.
with regard to, no, we don't need to back up, Mr. Wolf. Isn't it correct that 3D images allow for proper and most accurate measurements as opposed to 2D images? Is that a correct general statement?
I mean, generally, yeah.
Okay, that's my question. So let's go to the next topic. Let's talk about hydraulics on the Lexus SUV. What type of hydraulic system does the Lexus SUV have?
So it has a mechanism, I believe it's actually pneumatic. It's air-based system that raises it up and down.
Do you know what the name of that system is, sir?
No, not off the top of my head.
Do you know how it works specifically?
I do. Well, I mean, I know generally that there's a button on the interior where you can raise and lower the ride height.
And is that the extent of your knowledge of that system on the Lexus?
No, I know when you park it, it'll drop down the ride height. When you adjust it for different roadway conditions, it'll change the ride height.
Do you know what the height tolerances are? In other words, the lowest to the highest?
I believe it's around 1.25 inches. At one point in time, I measured it. I don't remember off the top of my head.
So you believe it's 1.25 inches up and 1.25 inches down? How do you apply the 1.25 inches?
I recall the total being like 1.25 inches, but I measured it at one point in time. I just don't remember off the top of my head.
Would you be surprised to hear that the tolerance is 5 inches on that vehicle?
I would be surprised. I don't recall it being that much, but I would need to double check.
Assume that the manual, as well as other informations, support that the tolerance is 5 inches and that specifically the vehicle can be raised 3 inches high and it can be lowered 2 inches. That's the basis for the 5. What was the suspension height of Miss Reed's Lexus that you used for your accident reconstruction analysis out front at 34 Fairview between 12 a.m. and 1 a.m. on January 29, 2022 to determine whether it was possible for the spoiler on the back of the Lexus to make contact with the eye of Mr. O'Keefe? If it was even possible, what did you use for a measurement of the suspension?
Matched the measurements from when the vehicle was tested, I believe on February 1st at the Canton Police Department.
What match did you make?
So we aligned the bottom of the taillight, actually the sheet metal right below the taillight. So we adjusted the height of the Lexus to match that.
Did you in any place document what level the Lexus was at the time of any testing, meaning the suspension? Did you document it all?
Yes.
Where?
Slide 107.
Can we have slide 107, Mr. Wolf?
And then if you could zoom in on the lower photograph, the gentleman with the blue shirt. Zoom in a little more, please. So if I may, we matched the bottom of the sheet metal here to photographs when it was at the Canton Police Department.
Sir, my question is, where did you document whether the suspension was at 0, whether it was +3 or -2? Where did you document that?
Right here.
And what are the numbers of the documentation of that?
I don't know. We were matching the photos. So I don't care what the numbers are. I care that the height is the same.
Okay, so I just heard you say, if I heard correctly, you don't care what the suspension is at. Is that your testimony?
No, I don't care what the suspension number is as long as the heights match.
I understand. I understand. So what was the suspension height of Miss Reed's Lexus at 5:07 a.m. on January 29th, 2022, while at One Meadows and colliding with the Chevy Traverse? What was the suspension height then?
We assumed it was the same as when it was at the Canton Police Department.
Exactly. You assumed, but there's no measurement like was just on that depiction. There was no note that said, okay, we're doing this very important and inches sensitive measurements to see whether the tail light on the Lexus makes contact with the Traverse, but there's no measurement and no documentation of what the suspension height was at One Meadows, correct?
So we took the closest measurement in time to the One Meadows event, which is when it was at the Canton Police Department. That was the best information we had.
Well, that information isn't very good because the vehicle had to go from Canton to One Meadows. And when the vehicle drives, the way the suspension system works, it's automatic. When you go above 20 miles an hour, the suspension comes up. And when you turn off the vehicle, it goes down so you can get out easier. So it would be improper to assume that the suspension at One Meadows would be the same at another location.
That's the only, sorry.
Was there an objection? Yeah. Go ahead and answer, please.
That's the extent of the information we had. We had it when it was at the Canton Police Department. We matched that height.
Sorry, sir. I understand.
But actually, you brought up a good point. It's going so slow when it's backing up that it wouldn't raise up. So the static position when it's backing up would be the static position.
But it wouldn't be going in backup from the Canton Police Department to One Meadows. It wouldn't be going back up when it's going in other locations, sir, right? It would be driving forward. It had to get from point A to point B.
Right. But as you pointed out, when you turn it off, it drops down. And then you turn it on. And then once you go above 20, as you indicated, it goes up. But when she's backing up, she never goes more than a couple miles an hour. So it's going to be at the same position as when you start, which is approximately the same position when it's off at the Canton Police Department a couple days later.
Do you know whether the suspension system locks when there is testing of the infotainment system?
Whether the suspensions, I don't know.
Okay, let's go on to the next topic. You're aware of the vehicle control, excuse me, Your Honor. Thank you, Your Honor. I'm changing topics to go back now to Fairview, 34 Fairview. You don't know what the suspension ride height at 34 Fairview was on January 29th of 2022, do you?
Correct.
So therefore, if you don't know what the suspension height was, because of course you weren't there on January 29, 2022. Therefore there's no measuring stick, as you say, you assert that you would have accounted for it in your methodology. So you don't have the suspension height for that key day, do you, sir?
I only have it 2 days later.
All right. So when you talk about key measurements, such as the spoiler on the top of the Lexus and the inches that are important as to whether things such as, is there a contact with the front eye, you don't have some data that would be relevant to that calculation, the sum data being the suspension height of the Lexus at that time, do you?
So we have some data. We have photos of the vehicle 2 days later. We don't know the exact height outside because, as you alluded to, we don't have a measurement on January 29th of it, but we do have it 2 days later. That's the source of the measurement.
You don't have the suspension height or the setting of the suspension of the Lexus that existed on January 29, 2022, do you?
Correct.
Now let's go on to another topic. Within the 34 Fairview on January 29th of 2022, I'm not going to go over them, but you asserted various measurements, height, width, with regard to the Lexus, correct? It wasn't just for the spoiler at the top, correct?
Correct.
And for all those other measurements that you talked about, you did not have the suspension height and the suspension setting of the hydraulic system of the Lexus on January 29th, 2022, did you?
So the hydraulic's only going to affect the vertical dimensions. It doesn't change anything left or right. It doesn't change anything down the side of the car.
Understood. But for the measurements that are affected by vertical, you didn't have the suspension height of the Lexus system on January 29th, 2022.
Again, I only know what it is 2 days later.
So now let's go on to vehicle control history, sir. You understand what I mean by vehicle control history of the
This is text stream information.
Are you aware of what is called the Bosch crash data retrieval system in Lexus vehicles?
Of course, we showed it on my slides.
And the Bosch crash data retrieval system in Lexus vehicles is sometimes referred to as the black box.
No, you're mixing up two things. So the Bosch is like the tools.
It's a question, sir.
So you answer that with the yes or no?
Is the Bosch crash data retrieval system the black box on Lexus vehicles? I just wanted to repeat it so we can.
I didn't hear what the objection. You objected?
I'd like him to be able to finish his answers.
Yeah. So the question was just asked. Can you answer that question?
No, it doesn't make sense.
Okay, next question, Mr. Wilson.
I'm going to ask the question, sir. The Bosch crash data retrieval system in Lexus vehicles. You're familiar with that? Are you familiar with it?
There is no such thing in the Lexus.
Lexus does not have a Bosch crash data retrieval system.
No.
Have you read the report of Trooper Paul,
Yes.
the May 2023? Does that report not use the exact words posh? Let me ask this. Do you recall?
Sustained. The
Okay.
objection sustained.
Let's go to the VCH system in Lexuses. Is the VCH system intended by Lexus as a diagnostic tool for their technicians, Lexus technicians, to assist in vehicle repair and maintenance? Is that what that is created for?
That's their stated purpose.
Right. And is a synonym for VCH TechStream?
Sort of. TechStream, similar, like Bosch is the hardware and software to access the black box data. TechStream is the software to access, for example, the pre-collision system, the PCS system, and the VCH, which is the vehicle control history. So TechStream which does a lot of other stuff, but does access that information.
You just mentioned Bosch, didn't you, sir?
So Bosch is not in the Lexus. You use Bosch stuff sold by Bosch software and hardware, and you walk up to the Lexus with all the Bosch stuff and plug it in and download the event data recorder, the EDR, the black box. That was my problem. There is no Bosch stuff in the Lexus.
I understand, sir. That was going to be the question that I was trying to get to, but you've explained it, so I don't have to answer the question. Let's go to the VCH database. That you say the stated purpose is to assist technicians at Lexus in vehicle repair and maintenance.
So I didn't say that was a stated purpose. I'm saying that's what Lexus or Toyota says is a stated purpose. It's being used in litigation all the time. All I know is that's what Lexus and Toyota says. But again, it came about right when we started seeing all the sudden accelerations in the Toyota vehicles.
So my question is the VCH database specific to Toyota and Lexus vehicles?
So it's not a database, it's software.
Is the software specific to Lexus and Toyota? The VCH?
Those particular acronyms are, yes.
Want to move to another topic, and we are almost finished. We have just two more topics, sir. How common were VCH events when Miss Reed owned the Lexus?
In 2022?
Do you know the ownership period of Miss Reed with respect to the Lexus? Do you know how long she owned it?
I have that documentation. I don't know off the top of my head.
Do you have an approximate?
No, I mean, it was a 2021 vehicle. Our accident's January 29, 2022. But I did get that information.
Do you know how many VCH events were associated with the Lexus of Miss Reed?
I did not count them, no. I have them all.
Do you
I was
have-
only focused on the ones around our time period.
Exactly. But do you have the number of events? Do you know how many there were?
I could get it for you.
How long would it take, sir?
3 minutes?
Why don't we come back to it?
Okay.
And we'll see if it's.
How about I start this so that we don't have to wait for it to boot up? And then when we come back to it, it's ready to go. You okay with that?
That's all you're looking at, sir.
Yep.
Thank you. And then pick your head up, please, so I can finish these two
Please,
topics.
go ahead.
So how often were VCH events recorded on the Lexus before January 29th of 2022?
Man, I have to pull this data up.
Fair enough. Fair
to
enough.
answer that
I
question.
assume that's going to be in what you're also pulling up.
That's the goal here.
Would the number be about 15? Does that sound right to you?
let's see, 1, 2. There's 18.
18. So there were your records show that there were 18 VCH events recorded on Miss Reed's Lexus, correct?
Before the subject one.
Right. Did you conclude that any of those events, other than the 1162-2, were a collision?
No.
Now let's go to reverse recorded events. Can you tell how many of those 18 events were reverse recorded events? And you know what I mean by reverse recorded events?
Yes.
The vehicle going in reverse?
Correct.
How many of those events were the vehicle going in reverse?
And this is before.
4. Other than
He asked you,
it
is
says
this before?
Yes, I'm sorry.
Oh, I would have to pull up the PCS file.
Could you start that and I can continue on with the questioning?
I got to, so the PCS file is I have a second laptop that
Here's
has
what I'm going to
texture.
do. That's not important for me to keep going and get through it.
Okay.
So let's just stay on the events, okay? Only one of all of those events, those 18, are you concluding that there was a collision associated with them, correct? Just one.
No, all those 18 are before. The collision is number 19.
No, I'm saying, I understand what you're saying, but for all the other events that are recorded, you're not, other than the January 29, 1162-2, you're not concluding that any of those were collisions, correct?
I didn't look at them. They were so far mileage away from everything.
But you're not concluding, even though they were so far away and you didn't look at them, you don't conclude from the information you have that any of them were a collision, correct?
Sustained.
Let's go to 5:07 a.m. on January 29th, 2022 at One Meadows, the home of Mr. O'Keefe.
Okay.
There was a collision between Ms. Reed's 6,000-pound Lexus and Mr. O'Keefe's approximately 4,500 Chevy Traverse. That's undisputed, correct? They collided, they made contact.
They touched.
Right. But the actual collision at One Meadows did not register the recording of an event on the Lexus VCH system, did it?
Correct. Too minor.
So, however, you want this jury, sir, to conclude that the glancing blow that you contend occurred at 34 Fairview Road by the same 6,000-pound Lexus in contact with a mere 216-pound man did register an event on the Lexus, correct?
No, the impact didn't register the event. As I pointed out, the trigger was from when the accelerator pedal went to 30%. The tech stream does not register crashes at all. It registers excessive acceleration, excessive steering, excessive braking, things like that, things that would be part of the maintenance system. So the tech stream will never register an event, even if you hit a wall at 100 miles an hour necessarily. It'll cause fault codes and things like that, but that's not what it does. The trigger here was transitioning into reverse and then gunning the accelerator pedal in reverse. And so when it went from 30 up to 74% throttle, once it went over 30 in that transition, that's what triggered the tech stream. It had nothing to do with, and that's why I'm telling you, I don't know when in that event the impact occurred? Because the text stream doesn't tell you that.
Thank you. That
You're
is
welcome.
exactly my point. The text stream information doesn't tell you when a collision occurs, does it?
Correct.
That's all the questions I have at this time, Your Honor.
All right, why don't we take our morning recess, James?
I don't even know what I'm watching anymore.
Sorry about that, guys. I was on the phone. I didn't realize we had a
Oh,
sidebar.
no worries. No worries.
At least well, actually, we're on our morning break, Kevin.
Oh,
And
okay. All right.
Leslie has stopped his questions while he's behind.
Is he okay? I mean that on a genuine level. Like, it's Alessi okay?
You know what the problem is, I think, with Alessi, and I've seen this before. You never want to question experts about their expertise. You can try to interview them, and he should have tried to go with the conclusion. You know, just hone in on that conclusion and see if he could somehow get him off that conclusion. And I think when you have somebody like this, just like they realized with that neurosurgeon, just don't go there.
Right.
Let it just be what it is, because the jury, although, you know, the neurosurgeon was great, this pounded in the fact that they don't have an answer for this expert. For 2 days, it's pounded it in, and he was left to repeat over and over again exactly his points he wanted to make. So I think this was an epic failure because they just didn't let him go.
For people asking for the Karen cam, I don't know how to get it. That's Kate that gets that. So whenever I know Kate had stuff to do this morning, so whenever she gets in, but I have no way to get it. I'm sorry. I just can't get it for you guys.
I was watching that kind of on a dual screen here.
Yeah.
I have my computers going, right?
Yeah.
Yeah, she doesn't look happy.
Oh, I can't imagine she would. I mean, everything that she does or puts forward from her camp seems to be coming from the onus of optics, right? We got to control the narrative via optics. It's never through data, because that sinks her every single time. And I cannot imagine that Karen is sitting there perfectly fine with Alessi's bizarre, the scary Mason behavior. That's the worst I've seen him so far. That's really wild. Him screaming in court, and not only is he losing substantively, he optics alone. He looks like he needs some kind of mental health intervention. I mean, for real though. Like, I worry about the guy now.
This has to create resentment in the jury, because they're being asked to make a large sacrifice. They're not going to work. They're not seeing their kids, or whatever they're sacrificing here. And to have that somebody up there, he's kind of like the senior philosophy student that's trying to use Socratic methods to try to break down the freshman girl to get in her pants. And it's just, I mean, you know what I'm saying? It's like, it comes across as like, but he's doing it with Welcher, who is, that's not going to work. And it's just like, it's just cheap tricks that he's constantly doing. And I just feel like it's, you know,
if that's any indictment on Alessi's game back in the day, oh my God, he would have been one lonely dude.
Yeah.
Oh my God. Yeah. Ladies love it when you just start screaming at them and stop mocking my hands. They love that. Oh my God.
It's like, don't you have anything else? That's what I'd be thinking if I'm a juror. I'm like, you're trying to split hairs on using all these. You're trying to he's caught continuously trying to put words into the witness's mouth, where he'll get him to say something, and then in the very next sentence he'll distort it. But Welcher's like, no, that's not what I said. You know, it's just the jury's gonna. It's so blatantly obvious. I don't see how a jury couldn't see through it, and I'm pretty sure most of them will.
Yeah. I mean, their lives are on hold for this, right?
Mhm.
Their lives are on hold, and this is what they're dealing with. It's completely bizarre.
I remember the
Completely bizarre.
first time I was on a jury, I was in college and it timed up. I was home from break, and it was probably like 6 or 7 day case. But one of the side's lawyers was really this shystery kind of looking character, and the lawyer kept trying maneuvers like this, and it rubbed the judge the wrong way, which was kind of clear. The judge kept kind of so when we the first and the other side's lawyers were high priced and slick, expensive suits, expensive shoes. And when we first got into the deliberation room, there were people, especially the women, that were very resentful of because of that lawyer. It just that lawyer rubbed them the so way that I knew that side had no chance. And a lot of it was that interaction with the judge, which isn't happening here. Judge Canoni's been pretty generous with Alessi, but nonetheless, if you have someone that's really just pissing off the jurors with his conduct, I think that's going to have an impact at the end how they decide things.
Well, he shouldn't be yelling. None of us
Yeah.
like to hear that. The
No.
raising of the voice, and it's not to make an emphasis for a sentence.
Yeah.
He can yell on a filibuster level, just
Yeah.
constantly. But I wanted to say that there's an account I really like. They're actually on Twitter too. I believe they're former law enforcement, and they made a comment I really liked. I'm looking for it right now. But essentially getting back to the point that if Alessi just could have just honed in on the fact that no matter all the data and everything he looked at, there's no way for him to say that that Karen Reed's car struck John O'Keefe, because remember, they're not allowed to say that,
Mhm.
and that killed him. That he could have just left it right with that, because he would have had to say, well, you're right. I can't specifically say that. It's my opinion that it
Right.
hit it, but there's no vehicle data point that shows that impact. If he just
Right.
would have said that, what a great point to make. Sit down, and I think
Mhm.
that I think he just did a terrible job. One of the worst I've probably ever seen.
Wow.
Yeah, I've never seen anything like that in my life.
And Jen has seen a lot because she's participated
Yeah,
in her
yeah.
career and then in her post career as an expert in so many cases.
Yeah, it's very rare. Also, you want to get the witness flustered, where they're
Mhm.
making offhand comments and they're looking disheveled, and instead, this witness turned the tables on Alessi, where Alessi was acting juvenile and disgusted, and even said, "But Judge, he's saying something about my hand." You know,
I don't even know what he meant by any of that. Still, I don't get it. I don't.
We couldn't
understand
see
what
it.
that was
I
about. No,
at least on our channel, we didn't have.
It
I
was
don't
in-
think that would
Okay.
help make sense though if we even saw Alessi. Maybe he had his hand up, but his reaction to Welcher in court, that he figured that was the way to deal. I don't know. No, it's too weird. It's too weird. Doesn't make no sense. No.
Jen, have you ever seen an expert witness like Welcher?
Yes,
What?
most of them
Okay,
are.
I gotta take a call, so I'll just leave you guys here.
Yeah, most of them, back to the question, are these expert witnesses good like this? Yes. And you get what you pay for. Some experts, we saw a couple in the Idaho case that weren't paid very much, and that were botanists talking about genetic genealogy that imploded, that actually took back their words. So you see instances like that, but high paid experts like this, who's in the six figures, who's got so much experience doing this, he knows this information inside and out. He's memorized his reports, memorized the data he's used. This is the norm. It's really the norm for a high paid expert but normally you don't see a defense attorney go down this route.
And what do you think the water cooler is going to be like with lawyers? Because everybody in every profession, they always talk about, what's going on in their sector. I could just imagine lawyers watching this and having a chuckle at the water cooler, like, have you seen the Alessi hand thing? Like, I think that's probably going to fly around a little bit, I would think.
Well, I'm waiting for Kate to cut that, and I'm sure she'll. Somebody's going to post it. I may even post it because it really. I think this is a defining moment. I had done a Twitter poll just to ask, what do you think about the fact that Alessi's taken over as the lead instead of Alan Jackson, who's the headliner? He's the quarterback of the team, and now you've got a second stringer in that's basically taken over questioning of their most important witness. I mean, this is who the Commonwealth called as their cleanup witness, right? And making a baseball.
Excuse me.
You know, he's the one that's supposed to hit the home run. He's the one that is supposed to answer how this collision occurred, to show how those scrapes occurred, and he did everything that we all wanted to know from an expert opinion, right? And then you have Alessi crossing him, and sort of Alan Jackson. I was watching him to see if he was going through the slides and things that was being referred to. He wasn't. Alan Jackson is not tracking. Not that he's not listening, he's awake and everything, but I just mean he's not tracking.
He's not as active. I've seen many comments, people, their sentiments basically being like, what AJ looks checked out. He doesn't appear to be on his game. He's not, some people believe he's not even paying attention. I mean, but you're right, comparatively to how he was behaving. Yeah, he does seem kind of, he's not all caring. He's not with it. I think he knows the ship is half underwater, or if not more already. Like, I mean, he knows. He's been around long enough to know.
You just have to wonder, and this is a question that I've just never understood, is for somebody, and those people are paid professionals. You know, they're making $500, $600, $700, $800 or more, $1,000 an hour probably on some cases. And they are purportedly, they've said it on camera, not that I believe them, but they have said it on camera, they're not getting paid. Yet, of course, their GoFundMe, and I know it's not actually, it's Go Send, you know, the equivalent. And on there it says for legal fees. So, you know, there's a big oxymoron there unless they've changed it recently. Back when they first said that, I looked immediately and it was definitely for legal fees. Legal defense. But now they're saying they don't get it. My whole point is this trial is going to last 2 to 3 months. I don't understand how, and saying that, yeah, well, you know, we'll get more business later. He was getting plenty of business.
Absolutely. Yeah. He didn't need this. No.
And look what they're losing, Boomer.
Oh my God. Yeah. Credibility alone, like, you know, and that's worth money for sure. For sure.
And it also made me wonder what their caseload is like. Like, I could never stop my caseload and just say, oh, I think I'm going to check out for 2 months.
At minimum, right? Yeah, at minimum.
So I'm left sort of asking myself, does Yannetti have any other cases? I know he does, but he's not working them. Neither is Alan Jackson, and neither is Alessi. It's just odd to me, the whole thing. Is it just because they want to be famous? Because they're becoming infamous.
Oh, big time becoming infamous. Absolutely there. I don't know. It doesn't make much sense. None of this really makes any sense to me either. I don't get it. I've heard the idea that this is their investment, right? They're invested in Karen and Karen's story, and basically they have this daydream that they're going to have, you know, duck boats at the end of this, and there's going to be parades. You know, there'll be mountains and mountains of money pouring in through media appearances and book deals and the like. I mean, it's so delusional. It is amazing. It's so delusional. I don't know how they think this is going well for them, let alone the scads of people that follow the Free Karen Read movement, right? They I don't know what universe they're in. They think things are going well. Are they not seeing what we're seeing? They think this is.
They're not looking at facts. I mean, they are already tied into their narrative that she's innocent, that she's been framed, that, you know, 2 law enforcement officers and a dog took him down. You know, when I first that, I literally thought this will never fly. And if you look back at
Right.
Boy's text
Mhm.
to her, he thought it would never fly. He's like, come
Oh,
on.
yeah. Yeah.
And you know what? Much to everybody or a lot of people's surprise, it flew with a lot of people and it proliferates.
Mhm.
Nonsense proliferates. It just needs to be said over and over again. And that's what's
Right. The
happening.
repetition. The repetition is key. It's key with all propaganda. Absolutely, it is. That's what gives it wings for sure. And there was a lot of that, a lot of repetition.
So is Alessi done? I missed the end of that.
Yes.
Oh my God.
They might have carted him off to the funny farm, Kevin. I don't know, man. You got to check.
I think unless it's so funny because a lot of people, Francesca is saying this right now, that Alessi, was a throwdown. In other words, that Yannetti and Jackson didn't want to take on this guy because he is so hard to discredit. And same with the neurosurgeon, right? So they threw Alessi into the fire.
Mm-hmm.
I don't know. I can't believe that's true. I think Alan Jackson has a huge ego, and I can't imagine that he thinks there wouldn't be a witness he couldn't try to tackle. And I think Alan Jackson could have made some inroads. But I'm just stunned at the defense's approach at this point. I'm confused.
I mean, he's trying to make the possibility that they got the analysis wrong, that there was no contact between the upper part of the taillight, which was the part that was damaged, and John's traverse. But that's also ignore the fact that they already established that the speed of the vehicle was less than 1 mile an hour. And it even the ARCA guys said last year that speed was too low to cause any damage. So what are we arguing over here? There's nothing to argue. The taillight was not damaged in the driveway, period.
Yeah. Oh, I know. I was thinking that myself. Like, they're splitting hairs over this again. It's like, well, was there any taillight found there? Was there any evidence?
Yeah.
So, like, again, I agree with you, Kevin. Like, what are we doing? And that is a sentiment that pops up in my head often. Like, what to what end, right? You walk out all of their bickering and arguing over like seconds or the taillight. And you're left with, okay, to what end? You guys still have to take it through to some sort of truth, some sort of proof, some kind of defense, and it's an exercise in futility. You're taking it nowhere. It's a complete
Maui
circle.
Swift reports that Sue O'Connor was saying that the jurors are nodding their head with Alessi and shaking their head with Welcher. I'm so sick of Sue O'Connell. I don't even consider her a journalist. She's a turtle rider. She's beshadowed herself. This is ridiculous. I mean, I talked to John about it, and she's trying to manage the press pool, Sue O'Connell, and has made this little role for herself on TV every night, got in the documentary. I don't believe that. I don't, the idea that most of those jurors are just going to sit there stone faced. That's what I would do. So this idea that I just can't stand her. I'm sorry.
I'm going to go out on a limb and guess there's at least a few jurors that were making that face that we saw Welcher do, which is that sort of mouth half open, eyes kind of wide, like you don't know what you're witnessing. Like, I think they might be confused at the outburst, at the strange behavior of Alessi. You can't say that that everybody's looking at that like that's fine. There's some of them have to be showing some tells, like, what are we watching?
That's absurd. That's like as though there was some big point scored by Alessi. There was actually literally no point there.
None.
I mean, best case scenario, you've planted some seeds that could be exploited later with your own expert witnesses, and that's it. So the idea that they were just sitting there going, "Amen, brother," no effing way. She's lying. Let's just call it what it is. We're not there. Right? It's so absurd that it has to be a lie.
It is absurd. It is.
Yeah, I would be shocked. We need to see what DePietro says. I trust him because he says he's actually pretty neutral. I mean, he will say, this scored some points or that scored some points. Obviously, he believes that Karen hit him because that's what the facts show. But when he reports kind of like Tuesday Gazette in a very, hey, these are the facts that have been presented.
Christina Rex is there. I think she's pretty neutral and objective, but a lot of people like Christina have decided not to report much about the jury, and I understand why, and that's probably very sound reasoning. So, but yet Sue O'Connell wants to push these narratives there. And I just, and I've heard from people that Turtle Boy comes in and hangs out in the press pool, and she's like, "Oh, wait," just
Oh, wow.
knowing what he does, which at this point
Yeah.
everybody does, having fantasies about Trooper Tully's and his family
Oh.
dying in a fiery class, but you're still buddy with this
Uh-huh.
guy. You have zero credibility, Stu O'Connell. Your career is going to crash and burn, and you deserve it.
Yeah. 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 You're supporting, like, she's supporting someone who's openly, continuously mocking the mother of the
Right.
deceased. Like
Yeah,
that.
exactly.
If that's not your line in the sand, I don't want to know you, honestly. Yeah.
Someone who a few months ago threatened to bring his mob to the kids' soccer games of the Attorney General in Boston, who isn't even involved in this case or his case. But I guess he's
Right.
trying to intimidate her into dropping charges against him. But it's just, that's okay with you, Sue? That's okay that he does stuff like that? He's your buddy? Give me a break.
Amazing.
And she's on the opposite political spectrum of him. But
Mhm.
that's just how expedient is. She's willing to make those alliances because, I guess, to get some of his crowd,
Right. Right. Yep. Yep. If you can't do it for yourself, if you can't find a way to get your own crowd, if that's what you really want, you're a useless parasite to begin with, in my opinion. If you're going to latch on just for, to leech some sort of boost in following, you're a gross little leech. No respect for you.
Maybe we get a distorted. Go ahead. Sorry, Jen. Go ahead.
No, I said we're just seeing that a lot.
Mm-hmm. Oh, yeah.
Maybe we get a distorted sense of things because we're too close to this case sometimes, but it's disheartening how many people have emerged to just grift on this that have no interest at all in the truth, no interest at all in doing the right thing, have no integrity. It just it's troubling.
It is. It is. But I think the numbers have always been that way. The amount of people who are willing to work hard and put forth a product or a service, whatever it is that they do, and take it seriously and develop it. It takes so much, right? You guys know that very well for what you do. You've put together an amazing amount, and it's hard to do. It's tough work, right? But there's, I think, a larger amount of people out there that would rather see an opportunity and just sort of sneak on the bus. They don't want to go through that. They don't want to have to put something together from the ground up themselves. Practice, work hard, none of it. Yeah.
DePietro says Alessi lost the jury, in his opinion.
I would imagine so. I think Alessi lost his mind. I mean, come on.
We love your infusion of humor.
I appreciate it. It's just I'm just puzzled by the whole thing, man. It's
you crazy Americans down there.
Right? What's that? Oh,
you crazy
no,
Americans down there.
No, I can't judge you guys on that level, man. It's not exactly sane up here, brother. I'd say North America's wacky as all hell. Oh yeah.
Have you read this new line of possible defense? In other words, moving away from Higgins and moving away from Brian Albert, and going to this, that John fell and hit his head after being attacked by Chloe, and then the plow driver pushed him up the lawn.
I saw that.
And Karen got backed up.
Yeah.
And cracked her tail light when she hit Higgins' vehicle. This makes some sense because this whole line of questioning seems as if they believe in a crash now, right?
Right. It's just not that one. Yeah, exactly.
Because the evidence is so overwhelming that at some point even they can't really deny it. So you're forced to, but it forces you into weirder and weirder theories like that one, and you've been screaming for a year that John went inside the house. Karen saw John go in the house and was attacked, and it was planned at the waterfall. You're just going to drop all that stuff and like nobody's going to remember it.
After all the damage that they did to people's lives and terrorizing kids, now you're just going to go, no, it's this whole other, oh my God. Anybody who followed that narrative for as long as they were putting it out, funded it, actively protested or harassed, jumped in with both feet, right?
Yeah.
Now your idol, your queen, is even given up that narrative. How do you feel now? You
Yeah.
should feel like shit. You should. You really should.
I told you somebody already cut it. An account called Bass Count 91025. And he says today in the Karen retrial, he keeps referencing my hand. This is a quote, what Alessi said. He keeps referencing my hand and saying I'm doing something when I'm not. Strange outburst, yelling something about his hands. And then they show it on here. Can't wait.
Gonna make the rounds. Gonna make the rounds now, right? Of course, yeah.
Jen, have you ever seen an expert witness like Welcher? He's very kind of different up there. The way he introduced himself to Alessi at the beginning of it, and it's kind of continued along a different style like that.
Yes, I have.
Mhm.
He's one of these experts that's just so confident, Kevin. He enjoys testifying. He knows his stuff. And
Court is in session.
The redirect, Mr. Brennan?
Thank you. Good afternoon.
Good afternoon, Mr. Brandon.
You were asked some questions.
Actually, it's morning, but yes.
You were asked some questions about the ring video from Meadows, which was John O'Keefe's home. And you were asked whether you're aware if the cameras had changed over time.
Correct.
The fact that the camera was replaced, does that any way affect your opinion to a reasonable degree of engineering certainty about your conclusions relative to that touching between the cars?
Absolutely not. It would have shown up as increased error when we overlaid the point clouds onto the photos or the point clouds onto the video. If it was an error, it would have showed an error.
Do you have any concern whatsoever that any of the information from the scan is in any way tainted, compromised, or inadequate?
That would be very hard to do. You literally press a button and stand there and watch it, and the laser does its thing. So I have absolutely no reason to disbelieve it. Additionally, again, if it was messed up, once you laid it over on top of the photograph, it would show the difference. So no, the data's fine.
Is there any evidence whatsoever that you've seen that any parts of your presentation were photoshopped?
No.
You were asked questions about the suspension of the motor vehicle of the defendant's Lexus. Do you have any information that the suspension at any point was changed?
No.
Yesterday, you were asked a number of questions about formulas. You took out your calculator and you were asked about different variables. Were those variables hypotheticals or were they related to this specific case?
So they seemed hypothetical. Again, you have to be careful when you're talking about failure forces on biomechanical things. For example, if you impact the hand with a, say, 1-inch narrow metal bar, that's a lot different than if you have a broad, say, plastic taillight or rear body panel. So when you have distributed loads, you can take much more. I told you guys about sitting on the bed, like how much you sink in. That's an example of spreading your load out. When you spread the load out, you don't sink in as much. So same thing with, forces on your body. If you take this pencil, I don't have to press very hard for it to pull in. But if I spread it out, I have to press much harder. So you have to look at the distribution of the load when you're talking about the failure. So when you look at the failure loads, it depends on what you're doing it with. If I hit you with a 5-pound 2x4 or a 5-pound pillow, they're both 5 pounds, but you'd much rather get hit by the pillow than the 2x4.
When you were asked questions about communications, when you would have communications with the Norfolk County District Attorney's Office, did you ever use encrypted apps to secretly hide your communications, apps like Signal?
No, I don't have any of those.
So the form of the question, ask it differently.
When you were communicating with members of the Norfolk County District Attorney's Office, did you ever use encrypted apps like Signal to communicate?
Objection, so, Your Honor.
I'm going to allow it.
No, I mean, I don't even know what that is.
Would you ever use an encrypted app so those communications couldn't be tracked?
No.
Would you ever have any reason as a professional for doing that?
Sustained.
You were asked about confirmation bias. You remember those questions?
I do.
Could I have slide 33 of your PowerPoint, please?
I'm sorry, what number?
Slide
33.
33.
Give me a second. $33.
You could zoom that in, please. A little larger so we can see it.
I cannot do it with one monitor.
You can't do it any closer than that?
No, not since I took down. Oh, hold on. Oh, here we go. Which part do you want me to zoom in?
Ms. Gilman can zoom in for you.
Sorry? Which part?
Ms. Gilman's going to do it for you.
Oh, there you go. Perfect.
If you could zoom in, please. Okay. On shift position signal, going forward, then neutral and reverse, does that data suffer from confirmation bias?
No, that's strictly electronic data.
When we look over at the vehicle speed, can we go to the left a little bit? Down. Vehicle speed ending at 2361 miles per hour. Does that suffer from confirmation bias?
No, again, these are direct readings from the vehicle. Again, that speed on this here, you have to correct for the slippage, which I do later on in the slide, but that is a direct reading from what the speedometer is seeing.
Acceleration at the end of that 10-second window, 74%. Does that suffer from confirmation bias?
No, that's a direct reading of a sensor. That's objective information.
I have no further questions. Thank you.
Wow. Anything, Mr. Lessie?
Your Honor.
Yeah, Your Honor.
Yes.
Thank you. Dr. Welcher, you were just asked questions about slide 33, which is a slide about text stream data. You acknowledge that text stream data, what you've called a trigger, like was on that slide, does not tell you if a collision even occurred, correct?
Correct.
With regard to the topic of confirmation bias that you were just asked about in slide 33, am I correct that all of the questions that Attorney Brennan just asked you were about data on that slide, correct? All that's on that slide is data, correct?
Now, he asked me more questions than just this slide.
But were the questions just about data?
On this slide, it was just about data.
Correct. But confirmation bias is really aimed at opinions and conclusions and alternative hypotheses. Isn't that what confirmation bias gets at?
So generally, yes. Again, I started this case with
It was
the
just a question.
hypothesis.
Go ahead, sir. Go ahead.
With the hypothesis that the Lexus didn't contact Mr. O'Keefe. And so I start what's called the null hypothesis, that this didn't happen. And then I look at evidence to either include or exclude the null hypothesis. So theoretically, my confirmational bias starts with a bias that it didn't happen.
Can you point to one document that shows that you analyzed whether there was no contact between the Lexus and Mr. O'Keefe? Can you point to one document? Was there one document on your slide presentation that analyzed the null hypothesis, as you call it, there being no contact at all? Was there any slide in your direct testimony?
So remember what I said, we start with hypothesis, we get more data, we whittle down our hypothesis to the final answer. I mean, I had 130 slides. I suspect I bored some of these people to death already. So I didn't include everything. There's thousands of photographs in here. There was a bunch of testing I did with the Lexus about backing, pedestrian detection that, you know, removed certain hypotheses. So if I was able to eliminate a hypothesis, I didn't present it here.
Sir, my question is not about.
All the slides show that, to answer your question.
Sir, my question is there any slide that says alternative hypothesis to whatever the label is, whatever the term, it says no contact between the Lexus vehicle and Mr. O'Keefe? Is there any document that you presented to the jury that shows that?
Any document where those words are written on it?
Correct.
No.
And to work through hypotheses, different ones, in confirmation, and to see whether there's confirmation bias, have you heard of scientists refer that as showing your math, so to speak, in working through hypotheses, documenting each hypothesis and how and why you rejected them? Have you heard of that term in the scientific world, show your math with confirmation biases and alternative hypotheses? Just a question. Have you heard the idiom, the phrase, show your math?
Your question is, have I ever heard show your math, period?
Associated with the application of various hypotheses to avoid confirmation bias. Have you heard of that term used in that conjunction?
Not really in that context. It's probably, I understand where you're going with it.
Thank you, sir.
You're welcome.
No further questions.
Dr. Welcher, you are all set.
Oh my God, thank you. Give me a minute to pack up and I will be out of here. Oh, I am plugged in, yes, thank you.
Excuse me? Yes, you can put your one.
Thank you. I'll do this out there. May I step down? Your Honor?
Yes, you can. Thank
Pleasure
you
to
very
meet you.
much. Mr. Brennan?
Commonwealth moves to introduce and play clip 26.
So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over or what if I clipped him in the knee and he passed out and or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
207.
Your Honor, the Commonwealth rests.
Okay.
Does counsel want to see me?
We do, Your Honor.
Okay, so should we send the jury out or should?
Probably, yes.
So jurist, so everybody can sit. So jurist, the Commonwealth rests. That means that the Commonwealth's case has been presented to you for your consideration. So I need to meet with the lawyers for a few minutes, so we're going to send you back out. I can tell you that it now appears that we're at least on schedule, if not a little ahead of schedule. So we'll send you back out for a short recess.
Rise to the jury.
Right. Can counsel come to sidebar, please?
That was quite the clip choice to end with there.
It's always a dramatic moment. The Commonwealth rests. Have they made the case? Have they made it beyond a reasonable doubt? Have they made it so far beyond a reasonable doubt that even if that gets chipped away a little bit by the defense, it's still beyond a reasonable doubt? Those are always the questions, right?
I think it was beyond a reasonable doubt. And furthermore, I think he is withholding a lot of information that we're going to see on rebuttal of the other witnesses. I think we're going to see more clips. And I think they have it lined out, assuming that, and I hate assuming like Alessi always wants his witnesses to do, but believing that they will keep with their general premise that they did before.
Yeah.
In my opinion of Brennan, it just from the layman's point of view, I believe he's at his strongest when he's on cross. So I'm very, very excited to see how he handles this next phase, because I believe that's his strongest suit is on cross.
Well, so you guys, are you surprised by anything, Jen? Now that this is the second trial, second prosecution rest, you've been involved in this case for a couple of years, one of the earliest on. Are you disappointed or pleased or surprised? Is there something missing here that you thought you might see?
The only thing I wish they would have been able to drive home the ring camera footage that's missing. But I do believe that is a little bit on the side of the importance. And I think it's important when you have such a strong case, you don't want to go down the road that is a little less strong and leave the jury on that note. In other words, they can't really prove, who did it. I think if they would have. And then the other piece, the only piece I really wanted them to bring in was the fit that was thrown in Aruba.
Right.
I'm
glad they didn't myself, but yeah, I you know me, I want to keep it as simple as possible. And I thought
streamlined.
That 9 week long trial last week was last time was a mistake. There's no way the jury could process all that. And I understand your point though, Jen, and it does go to motive and have a slightly I think a somewhat stronger case here for second degree in that with this new data that shows that John got out of the car based on the temperature of his battery, and then based on when he turned off his phone just seconds before he was struck, which really establishes quite powerfully that he just got out of the car, which Karen certainly knew that when she put it in reverse, and that's second degree.
Looks like Kate's saying Aruba was brought in through the niece.
Okay,
I suppose
that's right. We
it
didn't
was
get to
brought
see that.
in. Right.
Oh, thank you, Kate. Yeah, we didn't get to see that. I didn't see that highlighted much, but the witness that I loved on Aruba was the woman that Karen got so angry at, and she was on the stand.
Well, Karen, she sucks. That I remember that. Yeah.
I mean, it just really made you feel for the drama and the anger and the quick, fuse of Karen. They really brought that out in the Aruba. And then I think it also showed how tumultuous and how on the brink that relationship was, and that this, happened on the heels of that. I think that's the only thing I would have brought in. But you know what? Hank is more brick and mortar, like our host, Kevin.
Yeah. He likes to keep it streamlined.
Keep
I
it
agree
simple,
with
stupid,
Kevin.
right? Yeah.
I agree with Kevin on this one, though. Keep it streamlined.
Yeah.
Absolutely. It keeps all the evidence, in my opinion, more in focus. There's no distractions. The jury's, I would assume the jury would be looking at a more streamlined case. Like, the prosecution has it together. They're not reaching like the defense is, right? Splitting hairs, going down avenues that they're not really going to make the case. Streamlined, I think, is the way to go.
Let me ask you guys this, and then too. So, aside from considerations of what was proved or not proved, just your theory about what happened here that night is we now have some more evidence, right? That can maybe flesh it out a little bit. So, has it changed? What is your theory about what Karen did in that moment when she struck John?
I think she was angry. She was hurt that he didn't want to go home with her, that he wanted to go in with people that were sort of virtual strangers instead of hanging out with her and at the house and, having their moments. And so she was irritated. I think they got in a fight. It was pretty heated. He got out of the car and she looked in that rearview mirror and she threw it in reverse and meant to scare or possibly clip him. I don't think she meant to kill him.
Right.
I think she was surprised that he didn't get up and go have an affair with somebody. If you listen to her voice messages,
Right.
things like that. And then I think as she started to sober up a little bit and he wasn't around, she knew she killed him.
What do you think, Boomer?
Yeah, I think
that, or?
Similar to that. I think they were arguing in the vehicle on the ride over. She was probably already making her, making it clear to him that she just wanted to go home. No, he wants to hang out longer. He knows this is going downhill. She knows it's going downhill. I wouldn't be surprised if maybe John was putting the final statement out there that, we're done. This is just enough.
Right.
You can't even be a normal girlfriend. Come to the party with me. Everything's got to be an issue. I'm just done with this shit. Gets out of the vehicle. She's obviously, in my opinion, a very controlling, manipulative person with a hot temper, the weed whacker, right? And she started to take off, but this isn't over. It's not over. I get the last say. I get the last word. You're going to listen to me. I think she threw it in reverse, possibly to startle him, but I think is more a statement of like, this isn't over until I say it's over. She pops it in reverse, probably thinking that, she would stick her head out and yell at him, like, that she's been known to do, drunkenly scream and swear in public. She's done that a few times. I think when she hit him, she knew she clipped him. I don't think she meant to like mow him down. I agree with that. I think she knew she clipped him. She probably assumed, because she's drunk, logic doesn't always, make sense when you're drunk. Probably thought he'd be fine, but without a care in the world, she took off. I think that's my opinion. That's how it went down. And then, yes, like Jen said, she woke up and had that pang. You drink too much and you wake up and you start feeling like, what did I do? What did I say? Well, you might not know in the first few minutes because it's that fog, right? But John's not there. John's not here. Oh my God. Yeah. And then I think it all came crashing down. Oh my God. I hit him and, he's not responding. She knew that it was dire. And that's what makes it, to me, murder too, because in that time frame, when you believe it's dire and you do not call 911 for help, you just start the excuse factory. You start covering your own ass, right? You start looking for how do I manipulate my way out of this or soften the blow. Your selfishness right there is why I believe she should be charged with murder too.
What about the role of, so we try to put ourselves in the shoes of somebody else and what is their thought process?
Right.
That's what you guys both did. And is there also a role though for impulse control where there is something that Karen might have done that involved almost no thought? So just picture you're in an argument with someone and you're really raging and you punch the wall. It's not something that had thought to it. It's just an impulse control that you can't control. And if there's one thing that Karen has demonstrated throughout this whole process is that she has very limited impulse control. It may just be the way it seems to be just the way she's built. So is it possible that there was no real thought here? She just was angry and raging and drunk and
That's what I think.
and something. Was that Kate? Oh, Kate's here. Hi, Kate.
Briefly, I might have to jump off again. I'll explain later.
Okay.
But, I think that this was probably a low impulse moment. I think I can see two worlds. I can see two avenues. I can see where I think no matter what, she knew she hit something. I don't know if she knew right away that she had hit him, but she knew that she hit something. And I think that's why she took off and went right back to John so fast. Yeah.
Mm-hmm.
Yeah. Yeah.
We can't forget she did say he didn't look mortally wounded. And that wasn't a split clip. That was specifically, I thought I hit him, and he didn't look mortally wounded. So I think she even looked back and saw he was down and still took off. And that's why I think it has to be murder too.
Right. Yeah, I think she knew.
See why a statement like that I think it is problematic to her. I don't know for sure whether she meant then or in the morning. It's a little bit confusing if she meant, later in the morning, because she's screaming, "Is he dead?" So that would imply to me that you thought that he was mortally wounded. I don't know. But I think there's just that statement. I don't know. I think, again, you can't hit a pothole without knowing that you've hit. She knew she hit something. She was very specific in that last clip too, and I'm glad that he played it. She describes essentially what Welcher is theorizing here, that he was tagged in the knee. So I think that's interesting.
That stood out to me too. It was the clipped in the knee. He has damage on his knee. She called out knee. Yeah, that screamed out from that clip to me too.
So I'm going to relay a quick story about understanding whether you hit something or not, or roll over something or not. And this is terrible because I'm a dog lover, and I know there's a lot of dog lovers here, including Kate and many others. But my daughter and I were in France on a trip for her graduation, and we were in an Uber, and we were going about 1 mile an hour through these tight streets. And there was a dog that was a bulldog, a big bulldog. And he was walking next to the Uber, our car. And I kept telling the Uber driver, there is a bulldog there. Please be very careful. And sadly, I don't know how that bulldog got out in front, but that bulldog somehow got out in front. That Uber driver, 1 mile an hour, drove right over him, and we could hear it. It was like hitting a boulder, and he was just a bulldog. There is no way. And for those of you on a farm or whoever hit a squirrel or hit a raccoon, anything driving, it is so obvious when you hit something. Everybody's probably done something like that or been involved in something like that. So there is no chance, especially when on your big screen, you can see what's in your rear. I don't think she didn't know. So I want to make it clear that I think she knew, but I don't think her intention was to kill initially.
Yeah, I can see that.
So is the defense going to bring up any witnesses today, or are we going to just call it a day? You think what's the judge going to do here? Do they have somebody lined up?
Good question.
I don't think he did. I mean, who could guess that Alessi wouldn't have gone this whole time?
Right.
I figured he would too. Yeah, he's known to run the clock right out of steam.
And I thought Hank was going to do a lot more on the cleanup too. He was very brief too. So I expected that might go till like 1 o'clock. But did Hank leave anything on the table? So even in the article I read this morning from Anonymous Mass Lawyer, he thought he was surprised that more wasn't covered under direct, and he thought maybe, but the strategy might have been to leave something for redirect, but that doesn't appear to be the case.
Well, not for redirect, but Kevin, when they bring up their case, I think they have witnesses and clips that are going to offset the points that the defense tries to make.
Right.
Do you think that that's what he meant? I think that that's what the point is, that he's saving a lot. He's got a few aces in the hole that he's saving, I think.
And he does plan to present a rebuttal case this time, so you could see Welcher back on the stand, or I'm not sure. And to answer Solgo's question, I think Karen herself said the other day that they're going to be using a lot of clips.
Right.
I don't think they can really. They can't introduce just favorable statements. The only thing they can really do is introduce context because of the rule of completeness, from what I've been told.
Right. Yeah, I am interested in what the rules are on that, and I don't know. This is such a kind of, I don't want to say unprecedented, but you don't usually see this kind of use of clips in a trial. So, unfortunately, we don't have a lawyer on the panel with us today, so we don't know what the rules will be on that.
See if Alpha Fox Adam pops up in your chat again. Usually he knows he's
We did hear Judge Canone say today that we're ahead of schedule, so that makes me think maybe she'll cut an early.
I think so.
Cut an early day.
People keep asking about the Karen cam. That's Kate that takes care of that. I have no idea how. So
Yeah,
I couldn't get
sorry,
that.
guys.
Kate had things to do this morning, so I don't have the technology.
Somebody is asking, or several people, do you think they could be discussing a plea deal? I don't think there's a chance in heck. The CW has invested far too much money, too much, of their resources. So I don't think there's a chance for that.
I hear they're all watching the feds up there, stopping the trial.
Jeez.
Coming to the rescue.
Feds have entered the chat.
That's likely, right? Yeah.
Ha ha ha, Kevin.
Keep waiting for the ropes to drop in the middle of the room. I'll just start repelling. Oh, man.
No, Victoria and Angel, I agree with you. They seldom do, but I can tell you that I've been involved in one trial where they did a plea agreement late for 10 defendants. 10 defendants in a trial that we had already started. And they did one. So sometimes I'm just saying this is very well into it, but this was just a question that I saw posed that I wanted to address, that there's not going to be a plea deal, in my opinion.
Right. That would be unusual.
And so far, the play of the defense has been go till the wheels fall off. And they're so delusional, I don't think they'd recognize when the wheels have fallen off. I mean, they got Alessi up there.
Kate,
And
Sue
they always
O'Connell.
ask for a directive verdict right after the defense rests, or the prosecution rests. That's going to come, but that should be an open court, not in a sidebar.
Right.
Kate, somebody's telling Maui Switz is telling us that Sue O'Connell was reporting that the whole jury was basically nodding with Alessi and shaking their head at Hank.
Yeah, okay. That's just Sue O'Connell's bias talking again. That woman is insane.
It's more than bias at this point. It's just, I don't know what the appropriate word is, but it's dishonesty.
An attempt to hitch the wagon. Yeah.
Is she actually a report, like employed by NBC? Do they pay her?
She's on them every night now, and discussing not only this, but other, like she's on the other night discussing Russia and Ukraine. She's turned herself into it's NECN, I guess, or whatever. Yeah.
I do not care to hear about her opinions on world affairs, honestly. That woman, I mean, she's not an honest person. She's not an intelligent person. She's not a serious person, in my opinion. Sue O'Connell. She hates murder victims. She has a real disdain for victims of crimes. So,
is she is she a paid contributor, or is she a guest?
I believe she's a member of the staff on NECN, or what is that, NBC Boston, or whatever it is. I don't know, but I forget exactly. But I don't think she's a guest. I think she's a employee. Looks pretty intense in this picture, in this image.
Well, they're talking, a lot of people are saying, they're asking for a directed verdict up at sidebar, but that would be unusual. That just happens in open court for all to see. I can't believe they would be up there discussing pre.
Sue O'Connell changed her Twitter avatar to Harriet Tubman. PR is making a appeal to black people. Okay, thanks, Sue.
Oh my God. Oh yeah. All righty. That seems like a genuine move. What the hell?
And what's her angle here, Kate? She just trying to latch on to Turtle Boy's numbers, or has she become a turtle rider? She's hanging around with Jess Machado and
Sorry, it's more than just me talking in the house right now. Shh.
Kevin, if I could address your question, what I really think it all comes down to is just imagine if you talk in support of Karen Reed, all the flood of people that are directed, turtle riders and pink people, that flood that station with, oh my gosh, she's amazing. She's so smart. We 100% agree. We want her on more often. That is such a better receipt than to have, you can't stand her. She doesn't know what she's talking about. I think that's what she's trying to garner. Oh, somebody asked what a directed verdict is. It's basically saying dismiss the case because there's not enough evidence. And
Right.
typically a defense team will get up right after the prosecution rests and say that it's normal. We'll see if they do that. I'm sure they will. You're welcome, Chick. By the way, I love everyone's handles. Even when they DM me and tell me their name, I still call them by their handles because I just like the handles. Interesting.
Liz, the defense rests, Your Honor. Yeah, really. Yeah.
Unless he made his points, he won the day.
Yeah, that's right. Yeah. You think Karen was just whispering in Alessi's ear, there's nothing wrong with your hands, dear. They're just fine. He's still having his meltdown.
What do you think, Kevin?
I thought they got the same model. I don't know the exact thing, but I have no reason to doubt the testing that they did. But even like you said, Kevin T, like we said earlier, the speed was estimated that Karen was going was under 1 miles an hour. There was no, as Jen said, there was no objects that fell off that would have been clearly visible in the 2 inches of fresh snow there. It wasn't damaged in the driveway, period. I don't, even the ARCA guys said last year, they testified that the speed wasn't fast enough. I don't really understand why people persist in believing things because they don't look at the totality of the evidence. Yes, they don't, even on a refined subject like 227 or on this or on the tail light drive. I looked at this for 2 years. I mean, it just wasn't broken in the driveway. I don't. It's sometimes once a puzzle is solved, I don't want to investigate it much further because it's solved, and that's kind of what it is here.
Yeah, I agree with that.
Agree, Kevin.
Mhm.
All right, so jurors, we all, it happens several times a day, doesn't it?
Drink.
So we don't want to waste anybody's time. I know we've spent a lot of time at sidebar and we've had times that we've kept you in the deliberation room because we've been trying to sort through everything, trying to make this trial as efficient as possible, but also honoring and respecting all the hard work of the lawyers that's gone into preparing this trial. So sometimes I do understand that it's frustrating for you. But today we were able to spend some time this morning. I know we kept you in there almost half an hour and we've just spent some time now. So I can tell you that we are ahead of schedule right now. I still need to talk to the lawyers about something tomorrow morning. So we're going to send you home now and have you come back tomorrow morning at 9:30, because today I know we kept you until 9:30, and it doesn't make any sense where I already know I need to talk to the lawyers tomorrow morning to have you here for a 9 o'clock start. So tomorrow will be a full day, and we'll have you here ready to start at 9:30. Okay, so those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. And also, please continue to be careful with your social media use. So we'll see you tomorrow.
Rise to the jury.
There you have it.
Okay, so we could start a little later again tomorrow. Kate, if you probably missed this morning, but the word I had a little bit more word from sources that U.S. Attorney Leah Foley at some point is reportedly to have said when she looked at the investigation that Josh Levy ran into that, she described it as bullshit, a bullshit investigation. No way to confirm.
So Ms. Little,
no
if
way
you
to
can get
confirm
me
that.
whatever you're going to get me within the next hour, so that would be great. And I'll see everybody tomorrow morning at 9 o'clock.
You know, to your point, Kevin, anytime you have a full-on investigation, a grand jury investigation, hours and hours and hours spent by the FBI, hundreds of thousands of dollars likely spent on ARCA and other experts and investigative expenses and resources, and nothing happens. The most you can get out of it is somebody calling somebody a whack job with a loose balloon knot.
Yeah.
It's a real problem. And usually heads will roll in something like that because it should have been stopped earlier on. I mean, they just kept going, and going. And so I think something should happen, but I think that whole investigation was led by the U.S. Attorney's Office, not the FBI. And the FBI had to investigate to a degree, but really it was a grand jury investigation.
Yeah, so that's the reporting I had yesterday from really good sources on this, that there's deep frustration and disgruntlement within the FBI about the way the U.S. Attorney's Office, and particularly Josh Levy, conducted themselves on this investigation. And speaking to a source today, too, and so this is a good question for you or something you can comment on, that the FBI really kind of takes pride in the independence with which they run their investigations. They don't see themselves as working for the U.S. Attorney's Office. Obviously, there's a partnership there, but at the end of the day, they take pride in the independence with which they conduct their investigations. And they're unhappy with the way this played out. It was early on, it was pretty clear there was nothing there. And then there was nothing going on because there was nothing to investigate, but yet the U.S. Attorney wouldn't end it. So you can speak to that. Is that how, from your experience, the FBI felt kind of a pride and that they are independent? They're not working for the U.S. Attorney's Office.
The FBI does not work for the U.S. Attorney's Office, period. And the U.S. Attorney's Office doesn't work for the FBI. They're two independent functions, different functions, very independent functions. I've always said the FBI agents are nothing more than evidence gatherers if they're doing their job right. They're not judges, they're not juries, they're literally supposed to gather the information, and the prosecutors are supposed to present that information to a grand jury or file a complaint if it merits that. They work so closely together, though, prosecutors but I was trying to think. I can only think of one other instance in all my years where the U.S. Attorney's Office said they wanted an investigation. Does that make sense? Where we were called in and said, Jen, crew, the U.S. Attorney wants us to look into that. One time in 28 years. I mean,
apparently the eventual U.S. Attorney, but then assistant U.S. Attorney, kind of like a chief of staff, Josh Levy, went to the Boston head of the FBI to launch this after the meeting with Karen.
Yeah, that's how it always happens. So anytime something comes from the U.S. Attorney typically talks directly to the head of that FBI field office.
Right.
Now, some U.S. attorneys I'll name a name of somebody I worked with so closely as a line AUSA, Richard Roper, and then he became the U.S. attorney. And, you know, that's your buddy that you've worked with forever. So you know, he would call me and I would call him, and he's such a great guy. They didn't have that formality, but I could tell you it's very unique for something like that.
Do we lose Kate? Okay. All right.
I believe so.
So anybody wants to mention anything else? I got time, but we'll be back otherwise tomorrow, maybe a half hour later, because court is starting a half hour. Oh, let's see. Someone's got a comment up here. Let's see if I got this. Chat moves so fast now, and my chat window only showing like 3 at a time. Kevin Vinny was saying that Welcher should have done more tests, like doing crash dummies on the Lexus going 20 miles an hour in reverse. Thoughts on that? See, I'm not an accident reconstructionist, so I can't say what is normal here, what could be done. And as we see from Alessi over and over again, it has to be something that is based on peer-reviewed methodology as much as possible before they begin their investigation on this. But I can't say what kind of testing I'm not being an accident reconstructionist. I have no idea what they should or shouldn't do.
I think the problem is it would make him have to assume exactly where John was, and he stated he can't say that. So if you have crash dummies that, you know, you make one exactly to his dimensions, where are you going to put it? And to me, that completely bastardizes all the other tests that are so good. So I don't think
that's correct. And that is exactly what Welcher said. He did say that. He said that because they didn't know the position of the body, or sorry, where John was standing or where he wasn't, whether he was in motion, moving, bracing, that it would be to no effect to use a crash test dummy at that speed. They would just be damaging the vehicle, which limits their use of that vehicle. So if you were to just waste the vehicle on tests that they know can't be used. So
I don't know if anybody wants to address Tyler's comment here, because I have absolutely no idea what he's talking about. If you guys can see it on the screen, I highlighted it.
Wait a minute.
So he says, Yellow Cottage Sales, any word on the prosecution witnesses that didn't want to come or had some quid pro quo to testify? Hank has to turn over the names by next week. I don't know of any quid pro quo. No. That seems really strange and conspiratorial to me. It smacks of all this stuff. You know, Higgins proffered and this stuff that was being said last year that was nonsense then is now clearly nonsense now. But if there's something specific you're talking about, I really haven't heard it. Maybe these guys have.
No, I have not.
That is just what happens behind the scenes. There's no quid pro quo. You get a subpoena and you have to go.
Yeah.
And you can say your Fifth Amendment, you know, because you're involved in some way, you got to testify. And so nothing like that happens. It's so ridiculous. It's as ridiculous as saying that the CW is paying anybody, me or anyone else, for us to speak our minds on this case. It's so absurd that there's some sort of money trough that they have for this. It's so ridiculous.
Or some proffer deal, like, you know, he's got immunity now or something. It just gets I don't know what list of names, but are we talking about names for rebuttal witnesses? I really don't know what he's talking about. I haven't heard anything about that. Have you guys heard anything about a list of names that he has to turn over by next week? It's just something plucked off a Twitter world, you know?
Probably.
I mean, it's a
sounds of it. I see a comment here. Voice of Reason says, I bet if we look at Levy's background, we will see ties with Alan Jackson. Was there not a tie with Yannetti and the transition team with Levy, or am I incorrect?
So here's what we know. We don't know where the tie was. Someone obviously had a tie to get that high level of meeting. So Alan Jackson was brought in the case in July of 2022, and it was a month later that they got the meeting in with Josh Levy. Is that a coincidence? Maybe. But also David Yannetti worked as a prosecutor in the Boston office for 10 years. And so you're going to make a lot of connections in that way. So who had the connection? And Josh Levy was at the time a partner in Ropes and Gray, like the 19th largest law firm in the world or something like that. Very prominent law firm in Boston. Ropes and Gray, Rachel Rollins had told me she was estimating that about 30% of the employees at the U.S. Attorney's Office in Boston had at one time worked at Ropes and Gray. So there's a relationship there. But how they got that meeting, where, you know, how that went down, we just don't know. Is it Is there political enemies behind the scene? You know, we just don't know. You know, did Alan Jackson have some contact with the feds in Los Angeles that he used to exploit here? I mean, we know that Alan Jackson got the documentary through contacts. Terry Dunmore, the owner of Unsolved Mysteries, had never done a documentary like that before. She'd never done an independent project. All they'd done was Unsolved Mysteries for like 40 years. And so how did they choose her? There was like a connection there. I think, I forget what it was. And you know, I just talked to them yesterday about it, but I don't, you know, Terry is someone that has proved to be one of the rare profiles in courage here, who pursued the truth at some cost to herself. And has had a dramatic impact on this trial because of it with these clips. So, I mean, but how that originally got going, it was that, yeah, Alan Jackson does have a lot of connections because he's Hollywood Alan Jackson, you know?
That he is.
You know, all these guys are thinking, when you're working for the Los Angeles DA's office or the Boston DA's office, you're thinking about what you're going to do after your next, you know, your private practice or whatever. And you're trying to build those connections. And part of that, and if you can have connections to the media like Alan Jackson does, he's a good guy to know. It's a good, you know, it's to being friends with Alan Jackson is very useful to a lawyer trying to get their career going. Now, even just talking to Kevin Mahoney last year, you know, he said like him and David Nietti had told him still most of his business came through his website, and think that's how Karen found him, looking up DUI lawyer. So it's a grind. These guys have it's not all it's not glory. It's their profession is a grind. And from all my research, David Nietti was sick of it by the time Karen came along. He was thinking of calling it up, calling it, you know, because it's just the whole career. So you're dealing with wife beaters and drunks coming in your house, into your office every day. And it's just, it's not a glorious job. And, you know, these guys, he is an elite student, David Nietti, all the way through his life. He's clearly a very intelligent and capable lawyer. Wouldn't be surprising if he wanted something bigger or more interesting than representing drunks and DUIs and wife beaters every day. But that's the life of a defense lawyer, you know? So someone like Alan Jackson with all these TV, look at Betterow, right? He starts out going on Young Jelly's channel all the time, spouting nonsense. But because he builds a following through this, now he's someone that's attached himself to the Turtle Boy case, to the Karen Reed case. He's meant, you know, they tried to get him on their team. All this stuff is a way for him to establish prominence for himself, which expands his practice quite a bit. That's how they benefit.
Yeah. All the exposure, and to think he's come a long way since making cookies in a tree. Sorry, that was cheap of me.
What? Oh, okay. I get it. Took me by surprise.
Couldn't help myself, man. But no, I agree with you. Yeah, no, it is a grind. I could imagine that makes sense that Unetti would be burned out.
Yeah.
And maybe wanting something. I mean, a loose parallel, a very loose parallel. But when I mentioned like what could account for some of Turtle Boy's delusional state, right? Why would he do this? Why would he risk so much? Well, it's that sort of like last hurrah, I'm going nowhere. Now, Turtle Boy was actually going nowhere. You know, Unetti had a career, but the mental state could be similar, where you're not satisfied where you're at.
Yeah.
You know, you're not getting any younger. Let's just go for the full send, and you know,
most of your clients
down on the chips.
Most of your clients are factually guilty. Most of your clients are scumbags.
Right.
And so the chance to defend someone that you think might be actually innocent, and is this big case that's going to put the spotlight on you, I can see the appeal. Totally. Tanya says, can you explain the prosecution rebuttals during the defense's case? I'm new as Hank's dog expert, able to come in. I can answer this, but maybe you guys want to answer this. If anybody wants to take it on, it's so you get the chance. Yeah.
Go ahead, Kevin.
You have the option. Well, actually, Jen, you've spent 1,000 times more hours in court than me, so why don't you answer it?
Well, certainly Hank's dog expert will come in. What will happen if they put on a dog expert is they will make their case, and then Hank will be able to put on his expert to rebut what was said. So it works really nicely, and it actually gives the prosecution the last hurrah, if you will.
Mm-hmm.
Sometimes they'll bring the other person back on, but typically, and what I've noticed with Judge Canoni is she sort of shuts it down, really.
Right.
She doesn't let the rebuttal continue very long.
Right.
So yes, he will.
And we had no rebuttal in the first trial. It was the prosecution, they arrested, the defense, they arrested, and then we went to deliberations. But we have been told already by Hank there will be a rebuttal case here, and the rules for questioning are a little bit different. The rules for even what witnesses can be allowed are a little bit different. So the prosecution dog expert is Dr. Crosby, but there's no point to bring that expert in now. You bring it in after the defense brings in their experts to argue that John's wounds were created by a dog, and then you bring in your rebuttal witnesses. It's definitely a much cleaner way to do this.
Yeah, and it also doesn't show any credit to their case that there was a dog, right? If we bring them on first, it makes it look like that's a credible argument. So we have to bring it on, which is how they kind of, not to be mean, but messed it up last year. They were so focused in discrediting the defense, they never proved their case. This year, they proved their case, and they'll hold back on those rebuttal witnesses.
Thank you for our YCT legal counsel. She says rebuttal is discretionary by court and confined only to new evidence offered by defense, not up by the case in chief. So thank you for that. Very well said. That and many other reasons why we love you, Red Sky. Welcome, Matt.
Hey, how's it going? I missed most of today. I watched yesterday, but I was traveling.
Yeah.
So Alessi is kind of a joke. So are they done for today?
The prosecution has rested. The prosecution has rested.
God.
Yeah.
Did you see the meltdown, Matt?
Yeah. Did you see the hand spaz thing?
No.
Alessi, oh, wow. Okay. Yeah. Alessi lost his mind. He's like, Your Honor, he's mocking my hand. I'm paraphrasing. I can't remember the exact quote, but yeah. He shut everything down with this spaz out. It was wild, dude. Yeah, you got to check it out.
I posted the clip on my Twitter.
Did they play any more? Did they do any more Karen Reed clips?
Yes.
At the end. Yeah.
Was it a good one?
Right.
Or?
Yes.
She basically spells out what Welcher was asserting, right? That he was clipped in the knee. And she says, well, what if I had clipped him in the knee? It was the one about Yannetti said, well, I would have some culpability. It's that.
Okay.
Yeah,
that is a good one.
Yeah. It was a good mic drop.
I'm like shocked though that he didn't introduce like the video footage of her going back like by the temple that morning. Anything on her phone was not introduced to show that she called the father, to show like, because he did in opening statements, he did talk about her health data shows that she like was offline for like an hour and a half, maybe went to sleep. Connecting to the Wi-Fi at 12:36, was that introduced? I don't think so. And that would be probably from her phone. So that's what scares me about the prosecution resting, because like
it does seem like things that we hope for or expected. A lot seems to be left off the table, but yeah.
I mean, unless he's planning to bring it in rebuttal, but
yeah, Brennan seems to have that pattern though, and we've had moments where we were watching him on the direct, and I think Matt, you and I both said, "Well, oh man, is that all? Is he?" And then he comes back on the cross, and there it is. I think that's part of Brennan's strategy. So I wouldn't be surprised if we see a lot of what we've missed out so far on cross with Brennan.
I mean,
Matt, I asked the others, Matt, but we want to get your take on this too. So you went through the first trial. Now we got some new information in the second trial. Leaving aside considerations of reasonable doubt or the jury decisions, but just your idea about your best guess about what happened that night at that moment. What do you think happened?
I think that everything she said, most of what she said, I think is accurate, where she says, I slowly rolled off the road, and she giggles a little bit. I think that happened. I think she was expecting him to turn towards her car and be like, come on, like, why are you leaving me? And he turned towards the house, and she freaked out and slammed her foot on the gas, hit him with the car, saw him go down, saw his shoe come off because she might have ran over his foot, and took off and started calling. And she was outside, connected to the Wi-Fi at 12:36, started calling. was a little panicked, saw the damage on her car, and then she recorded herself at 12:41 walking into the house. And that was her alibi video. And then she calls back 20 minutes later saying, John, nobody knows where you are. I don't think she was like fully lucid where she knew what happened, but she knew. And I think at 4:30, that's when she knew. And she was freaking out. And she wasn't freaking out because of him. She was freaking out because she was in so much trouble and she was backed against the wall and she was trying to figure out how to get out of it. And I think that's what we saw all that morning. And that's why I think that footage of her going back to the scene of the crime and whatever's on her phone would show that. And I think it's a big part of the case.
Do you think we're any closer to second degree than we were the first trial? Which there seems to have been a unanimous, the jury seems to have been unanimous that second degree was not proved. I know that we can debate that, but I think that's probably likely. Do you think we're closer to it now? Is it more in play?
I don't think without that extra information. I mean, I think that's the stuff that, I mean, it depends on what his closing argument is, right? Like if he's going to tie it together in that way, then we could be. I think Lally did not even address second degree in his closing statement. So that was the problem there. But I do think there's enough that Hank could string together for a second degree in his closing.
Like it was pretty big that we now know exactly what time John got out of the car. And that was just seconds before John, his phone stopped moving. So Karen certainly knew that he had just got out of the car. So when she made that decision to put it in reverse, there's no question she knew
that
he was there. So there's, not that we don't have to show whether she meant to hit him or even meant to scare him. All we have to show is she put it in reverse at 24 miles an hour when her boyfriend was right there. That satisfies. Go ahead.
Yeah, I'm sorry. 75% depression of that accelerator. Bam. That's what does it for me as well.
Yeah. Because I mean, I've hit the gas in the wrong direction before, but it's like almost immediate where you realize it hit the brake. So it's not an accident. Like,
right.
It was rage.
It's usually 50 something feet before you realize, yeah, no kidding.
Yeah, there's no way.
Yep. That's what I think too. And it's funny because a lot of FKR people have asked in my, on my Twitter feed, well, have you ever gone 24 miles per hour? You can't control your car. And I kind of giggle. Yeah, we do that for a week in TVOC, go backwards way faster than that. But for anybody, I mean, for that short length of time, seconds, yeah, you can have your car go backwards that quickly and that fast. It wasn't like she was doing an obstacle course backwards.
Right.
No.
She was going to hit whatever she hit. Whatever was back there, she was going to hit. She wasn't stunt driving. She might, even the lane assist might have assisted her from hitting the curb. Who knows? But like, she just hit the gas. She wasn't thinking. She was just in a rage. And she saw red and that's it. Like,
yeah. The assumption
way to put it
that she was aiming. Right. Yeah. But I don't believe she was aiming either. Like it was some kind of stunt driving. It was
I know.
Move, right? Like it's just pop in reverse, hit the gas, and that's that.
Yeah, and what happened. In other words, what happens if she hits him, fine. If she doesn't hit him, if she just scares him, it's all good.
Yep. She didn't care. Yeah.
But there's no way in hell she didn't hear that glass smashing off the back of her window, no matter how loud U2 was playing. She heard that glass smash because Lexus lowers the volume in reverse. And I just think, there's no way in hell she would have went past him too to see him on the ground before she put it back in drive. So.
Right. Well, he didn't look mortally wounded, right, Matt?
She was like, he's fine. He just lost a shoe. He's making a snow angel. He's fine.
No big deal. Yeah. He was very flippant about the whole damn thing.
One of my favorites is when she says, and I thought maybe he came out to flag me down, which was the reaction I was hoping to garner. I just laugh at that because that speaks again to her motivation. She wanted him to be with her. Yeah. I don't say that mind reading. I say it because of her comments. She wanted to be with him.
She wanted a reaction
that way.
Mm-hmm.
And she was looking in the camera, I think, and she was expecting him to be like, Karen, don't leave me here. I think that was the fight. She was like, I'm going to leave you here. And she expected him to be like, no, I'll come with you. And he was like, F her.
Leaving aside the nuttier part of the Free Karen Reed world, how does their defense team feel right now?
Oof. They're gonna say that. I mean, I know she said in text to Turtle Boy. I don't know if she's ever said in an interview where she said that she never went in reverse, but I believe she did. And then the other day outside of court, she's saying, well, after that event, which happens all the time in my Lexus, he was still moving around for a few more seconds. That's totally different than being factually innocent. Like,
no kidding.
It's wild that she said that. Like, I don't even know what she's thinking.
She said she never went into reverse on the courthouse steps a couple days ago.
Oh, really?
Never went in reverse. You got to find that clip and do a funny thing. Actually, Carrie Lama, I love Lama.
I've seen that clip. Yeah.
She did a clip with her saying, or with the information about the reverse, and then the clip that she said she never went into reverse. It was super effective.
So is Arca going to support that? Like, that's what I'm thinking. Because, like, Karen does say things based on what the evidence is. Like, you can see it all along. She took a year and a half to come out with this story. And it was after she had that voicemail of her going in the house at 12:41. That's when they established that she was home. So she said she was calling and texting. 12:33, she starts the calls and texts. And at 12:41, that would fit. But connecting to the Wi-Fi at 12:36, that's the problem. But I don't know if they entered that into evidence yet or at all.
I don't know why that's a problem. I mean, I looked and it's literally 2 miles.
Oh yeah.
5 to 6 minutes. And I think she took off like a bat out of hell. I don't think she was driving the speed limit. And, Google Maps does it based on you going 25 miles an hour residential. I think she was going double that. I think she could have easily connected with the time we have to work with.
Oh yeah, for sure.
I just want to respond briefly to the many people who have been kind of messaging me over Facebook and over email over the last day. I read them all. I apologize if I don't always have time to answer them, because what happens is if I'm somewhere where I'm only reading it on my phone, it's kind of hard to type an answer. But just because some of these people email me a lot, and it's like I am reading them. I'll reply sometimes I won't, but I do read them all. Just wanted to. I don't want people to think I'm ignoring them. That's all. All right, so. Matt, court tomorrow is a half hour later. I don't know if that helps you at all. Judge got some business to take care of in the morning. And so I guess I'll be back around 9 tomorrow. Guys, anything else you want to go into so we can go have lunch? Call it a day?
Really quick, they wanted to ask what our thoughts were on whether Karen would take the stand. I'm going to say there is no chance in heck she takes the stand. Ever. That's my opinion, but I don't know what you guys.
She can't handle the truth.
I don't think she'll take the stand. But just in closing, I can't imagine this isn't going to happen. It's just I can just picture it. They're going to be sitting at dinner over a meat blob tonight with the John Tesh on, nice and quiet, and the lawyers are going to be sitting there, and then someone is going to awkwardly tap their plate with the fork and say, "Bob, what's up with the hands, man? You gotta tell us what is up with you and your hands." That was a triggery spaz moment. We gotta know. There's gonna be a discussion about it. There has to be. You're gonna love that when you see it, Matt. You're gonna lose your mind.
I was actually just thinking this when Mama Gigi said this. I love that Hank brought up the signal with Welcher. So Matt, Hank on redirect actually asked Dr. Welcher if he had ever communicated to anybody over a secret encryption app like Signal.
Oh, I love it. I've been saying that ever since I heard that the Hank should be asking every witness that, but now he's setting it up completely.
Yep. He did.
Arca is going to get destroyed. I cannot wait.
Same. Yeah, they are. Yeah, it's going to be brutal, man. It's going to be brutal.
Karen's going to have to get on the stand, I think. I mean, I don't think that they want that, but I feel like, that might be the only hope. She's made up so many stories. Like, she can get on the stand and just be like, actually, this happened, and just tell a whole new story. I mean, I don't know.
Yeah, it's getting that bad, man. It's getting that bad. They're having to abandon all.
Who do you think their first witness is?
I don't know. Like, because in opening, he said that they were going to bring in an eyewitness that saw him go inside the house. They said that there was data that proved that he went inside the house. So I would think it's one of those.
I would think a medical examiner, and I don't know who they have this time. We know Sheridan, they do not have, but someone to come in and challenge the injuries.
Yeah, Yeah.
Why aren't there broken bones? Why aren't there more bruises? Blah blah blah. But I guess most of these experts are being flown in, so it depends on travel and other things like that. So, or maybe Lucky. Don't forget about Lucky.
Oh yeah.
Lucky, so coerced. I love
It's-
to play all those clips of Turtle Boy just crucifying him into submission.
Yeah, I think the poor guy was manipulated by Karen's private investigator to start with, Paul Mikowski. I'm not trying to accuse anybody of anything. That's entirely speculative, so don't sue me, Paul. We had and while working on the book, we did have someone reach out to Paul, and he was a gentleman.
So Matt, you're the only one here that thinks she's going to take the stand, or your just percentages are way higher than ours?
I think, this defense is so backed into the corner at this point, and like you never want the defendant to be on the stand. Usually it's only in like self-defense cases where it's like almost necessary. I just don't know if they're going to be like, we need to totally change this up. And Karen, just say you were fighting and you were scared and drove away. And you made up all these lies for years and years and years. Like, I don't know. I just don't know what the defense's defense is going to be. Like, I just think that they're so screwed because nothing holds any water. I don't know.
She that's poor impulse control. It just seems like a dream for a good defense lawyer. I mean, a good lawyer to cross her.
Yeah. I mean, Hank will destroy her. And I know he'll make her flip out too. We're going to see the real Karen if she does get on the stand.
One thing is, and somebody put this in here, I thought this was interesting. Could their eyewitness be Karen?
It has to be.
Said that she saw him go in. Or are they thinking about, who was it that said that? I think it was Higgins that said
Higgins saw a tall, dark man.
Figure or something like that.
But that's not John, and he knows John, and it doesn't make any sense. Like,
it's Colin. It's Colin. He didn't know. He had never met Colin.
But Colin's not really that tall. I mean, Brian Albert Jr. is extremely tall.
Yeah, but I think it's just the way you're sitting at a table. So Brian Higgins was there early, and Colin left as the Alberts were getting there, and Higgins got there with the Alberts. So I'm pretty sure it was Colin. And just because he's not short by any means, Colin either. So he just got a glimpse of someone as they were leaving, and that's exactly what Colin was doing.
Yeah. I mean, if they're going to try to say that was John, that's ridiculous. He knows John. Like, he was just at his house the week before, and his girlfriend was trying to bang him. So, like, he definitely knows who John is.
Okay, you ready for who I think their number one witness will be? Or who I would put on? You guys don't like this. You've already said you disagree. Proctor. I put Proctor on. He is my...
Really?
He's my Mark Furman. I put my Mark Furman on there, and I get all this nastiness. He was the head of the investigation. I try to paint him like a misogynistic pig, and he muddied everything up. But that's who I put on if I'm in charge, which I'm not in charge.
It's risky, though. It's risky. I mean,
What
I don't
is the
think.
downside? Tell me the downside, because I can't figure out the downside.
Karen is not looking likable, so we're just looking at a likability optics kind of angle here. Up to this point, Karen looks like an insane person. There's clips of her looking like an insane person. The evidence is very strong that she did it. The risk to me would be they bring Proctor to do what you're speaking of, to absolutely take that angle. I think that's the only reason they would bring him, if they were to bring him. But in the jury's perception, though, they might already not like her. I'm not saying they're ready to vote guilty yet. They haven't seen the rest of the trial, but they might find her disagreeable, and the faces she pulls, the clips, it could backfire. They might sympathize with Proctor. They could be disgusted and sympathize. It might just be moot, or that's a dangerous risk, in my opinion.
No one has sympathized with Proctor except other law enforcement, for the most part, because we understand behind the scenes people say things they shouldn't, but no one thinks that he should have been talking to his high school buddies about it. No one thinks that in law enforcement. If they think that, you're not supposed to talk about ongoing investigations to anyone other than fellow officers.
I just think, the rebuttal. So if Hank has an arsenal of rebuttal information, right? So like I think the defense is going to weigh that very carefully. They only want to put stuff on that he can't rebut. So like anything that Proctor says, you know, because he did the entire investigation, they can rebut everything. You know what I mean? Like every single part of the investigation he's going to talk about. So Hank could rebut any single part. So if they only bring in like the medical examiner or the dog bite lady, they can only rebut those parts. I think they're afraid of putting in too much information because, you know, he could rebut it with bringing in Mr. Reed and his statements on Fox 25. Like they're going to be very careful what they put on, in my opinion.
All right, can we call it a day? I really want to go have lunch and take a nap.
Yeah.
Oh, absolutely, Kevin.
Take a nap.
Absolutely.
Goodbye, y'all.
All
Thanks,
right,
guys.
thanks for having me.
Hopefully see you all tomorrow.
All right.
We'll do.
Okay.
All right.
Good night, have a
Bye,
good day,
everyone.
everybody.
You too, man.